Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear, hear, all persons having business with the Appellate Division. Draw near, give your attendance, and shall be heard. Please be seated.
Seemed dark. It seemed dark? Yeah, it was overcast. Good afternoon, all. Welcome to the Appellate Division, First Department. Oral arguments for today, Tuesday, November 29. My little sheet says 7 hours of oral arguments. So again, we know that it's not happening. We'll just put it in the garbage. Again, please only ask for the time that you actually need to argue the case. Please, again, keep in mind that we have read your briefs. We are fully familiar with your arguments, okay? So with that, first case, People v. Jose Bricio. Four and 1 and 4. Cusa versus New York City Department of Finance.
Good morning, good afternoon on behalf of the petitioner. I'm requesting 5 minutes for argument on rebuttal.
I'm sorry, 5 and 1?
And 1, correct. Respondent 3, please.
Yes, 3 and 1 and 3. Excellent. Matter of Jeremiah is submitted. Kamara versus 323 Paz owner.
Appellant 3 and 1.
Respondent 5.
3, 1 and 4. SG and Infant versus Harlem Village Academy.
Request 4 and 2. Respondent request 4 minutes, Your Honor.
4, 2, 4. People versus Leroy Gordon. 4, 1 and 4. City University versus Utica First.
Appellant request 4 and 2. Respondent request 5.
4, 2 and 4. Please note that Justice Rodriguez is recused on that matter. Atara versus Masaryk Towers.
Appellant requests 5 and 1. Respondent requests 3.
And respondent, second respondent, 2 minutes.
Who's the elevated Centennial? That's you? I'm sorry, and how much were you requesting? And Masaryk Towers, 2? 5, 1, 3, and 2. Ladder Capital versus 1250 North.
Appellant 1250 request 5 and 2. And guarantor appellant 5 and 2. Respondent 7.
5, 2, 5, 2, 5. People versus Ephraim Santiago. 4, 1 and 4. Ning Yang versus Karen K. Submitted. National Auditing versus 511 Property.
Appellant request 5 and 2.
I don't believe there's a respondent. I'm sorry, is there a respondent? No? Did you wish to submit? Hello? Did you want to submit? 2. Runway Towing versus New York City Department of Consumer Affairs.
4 is easy. Respondent 5.
I'm sorry?
Respondent 5.
Okay. 4, 2, and 4. People versus Naomi Montarola. That matter is submitted. Zanny versus Gomori. Oh, submitted. People versus Derwin Mercer.
Appellant requests 4 and 1.
Respondent request
4, 1, 4. Regan versus W Associates.
Appellant 7 and 2.
Respondent requests 4.
4, 2, and 4. People versus Curtis McDaniel.
Appellant requests 6 and 2.
4, 2, 4. Aragon versus 100 West 74th Street is submitted. First case for argument, People versus Jose Bricio.
May I proceed?
Please.
Good afternoon. Rebecca Besden with the Office of the Appellate Defender for Appellant Jose Brioso. When Mr. Brioso was a child, he was the victim of a brutal machete attack by gang members who broke into his home in the Dominican Republic. Both of his arms were nearly severed. He spent 5 months in the hospital. His severe pain and impairment continued to this day, and the emotional trauma was so severe that he attempted suicide soon after. This incident began when Mr. Brioso was stabbed, attacked, covered in blood, stabbed in the neck by a group of men wielding knives, leaving him covered in blood. This offense must be viewed in the context of the very specific trigger that preceded it, and his panicked response to this attack must be understood in this context.
So the woman who was in the vehicle that he pointed the gun at, was she in any way connected with the stabbing?
Your Honor, there's no information to the record to indicate that, and our argument is not that.
And when he fired those 3 shots in the air, were the people or the individual who stabbed him, were they in the air at all?
There's no information in the record about whether they were in the area or not.
And this was a plea bargain. He had 9 open cases and 2 indictments, so he had 8 other cases. So this was a package deal, right? It covered all of those 8 cases, wherein he received 5 years for 8 cases.
Well, Your Honor, respectfully, that's not exactly correct. While the prosecution has characterized this as a global disposition, Mr. Brioso pled guilty on each of the felony indictments that he faced.
For a total of 5 years.
He received a separate sentence on each. Yes, they did total 5 years, but
And if he had not received a separate sentence on each, I'm assuming it would have been at least 8 years, because we're talking about 8 cases, a total of 9 cases, excuse me. So it would have been at least 9 years, even if he had just gotten a year on each. And I don't even know that the minimum would have been a year, right?
Well, Your Honor, the vast majority of the cases were misdemeanors, such as a turnstile jump, a marijuana-related.
But there were 2 indictments, right?
Yes, and he, as I said, he pled to an offense on each of those indictments and received a sentence. So this isn't a situation where any felony indictments
This
were.
plea covered a robbery with the knife, which occurred 8 months after this shooting?
No, Your Honor, he took a separate plea on that offense, and I think it's important to note that following that offense was when he was first connected with the Osborne Association, which extensively worked with him and delved into his trauma, and they concluded not only that his
What did he
trauma.
plead to? What did he plead to on the robbery case?
He pled to robbery in the 3rd degree, Your Honor. And
And was there any psychological exam of Mr. Brioso after this incident that related it to his childhood trauma?
well, Your Honor, the Osborne reports did a detailed investigation into his history, and he had been diagnosed with schizophrenia and as well as substance abuse disorders. They explicitly linked his past trauma to this event. They
So
said,
how old was he when these crimes were committed? So how old was he in 2019?
I don't have his exact age, Your Honor. I believe he was in his 20s.
In his 20s?
Yes.
And the trauma occurred in the Dominican Republic when he was
He was
his teens?
he was attacked with a machete when he was 13, Your Honor, but tragic, and he also
Now, didn't
suffered.
this happen when he was 30? His date of birth was April 13th, 1989.
That's possible, Your Honor. I don't have his age in front of me, but I think.
And the gun that he used in this case, he gave to someone who was young. He
Well, that
transferred the
person-
gun that he had discharged 3 times in this case. He turned that over to someone who,
Yes,
ended up-
Mr. Molina observed that he was injured and
To a
covered in
juvenile.
blood at the time that he handed the gun to him.
Thank you.
Thank you.
May I proceed?
Please.
Good afternoon, Your Honors. Kalani Brown on behalf of the respondent. the Bronx County District Attorney's Office. Your Honor, the people respectfully request that this court affirm the defendant's conviction because the defendant's conviction was far from excessive, and given the egregious nature of his crimes, the sentence that was imposed was fair.
To what extent did your office take into account the fact that before the defendant shot the gun in the air and so on, that he was in fact attacked and stabbed and was covered in blood himself?
Your Honor, I'm not sure to what extent it was taken into, but I am aware that it was taken into account that the defendant was covered in blood during the time. There was no additional circumstances or information to determine why that was.
Wasn't something that anyone in your office thought it would be helpful to know in deciding what his level of liability or culpability should be?
Your Honor, after the defendant was arrested in this matter, the defendant did enter warrant status because he did post bail, but he did not return to court. And so the extent of that investigation was not clear. And Your Honors, the sentencing court was in the best position to determine the circumstances that the defense has presented.
And while he was on that warrant status, he committed at least one other crime, or was there more than one other crime?
Yes, Your Honor, he committed 2 additional crimes. So after this instant matter, it was only a month later that he was arrested for felony auto stripping. And in that case, the window of the complainant was broken, the windshield was cracked, the back seat was ripped. And then 8 months after that case, the defendant was arrested again for robbery in the 3rd degree, in which the defendant, with additional defendants, held a man at knife point and demanded that he give them the jacket and his cell phone.
So the minimum on the CPW-2 would be 3.5?
Yes, Your Honor, to 15 years.
And on this one, he received a total of 5 years for the CPW-2 as well as the robbery and auto stripping and
Yes, Your Honor.
Cumulative.
Yes, Your Honor, and those matters were to run concurrent to each other. And so the people did take into consideration.
Is it accurate to say that the sentence that he received in this covered 9 matters?
Yes, Your Honor. The people did take into account, the defendant, was in warrant status on multiple misdemeanors and had 3 felony indictments. And so the people took into account, as well as the sentencing court, all of these open cases.
But they weren't covered, right? He had the plea on, there was a plea taken on each of the cases, right? It wasn't that one plea covered everything else.
Yes, Your Honor, it was separate pleas. However, it did happen at the same proceeding is what I'm alluding to. And so, Your Honor, as you've mentioned, the defendant is set to be conditionally released as early as 3 months from now, and so in February. And the post-release supervision, the purpose of that is for rehabilitative purposes, is to help with reintegration. It will allow the defendant to be able to get the necessary services that the defense is claiming that he so necessarily needs.
Well, the Osborne Society was prepared to set that up in the first place before the incarceration, correct?
I'm sorry, can you repeat that, Your Honor?
The Osborne Society was prepared to set up a program of rehabilitation had he been released in the first place, correct?
Yes, Your Honor. And so I'm merely
That was not an offer that you were interested in discussing or considering instead of requiring a period of incarceration, is that right?
Yes, Your Honor.
Thank you. So to that last point, your adversary just mentioned that he would be on post-release supervision in a few months. I saw that you were asking for a reduction in sentence. Were you also asking for a reduction in the post-release supervision time?
Yes, Your Honor, we're asking for reduction of post-release supervision as well.
And so it's 5 years post-release supervision. How much time were you requesting that we reduce the post-release to?
We would request a reduction to the minimum on both components of his sentence, Your Honor. And I do want to...
So the minimum on the post-release is 2?
2.5, I believe, Your Honor.
2.5. So again, given all of his issues, trauma, et cetera, why would he not be a perfect candidate for 5 years post-release supervision so he could continue to work with Osborne and other agencies?
Yes, Your Honor. Because Mr. Brioso has a lack of education, he has only an 8th grade education, he's a Spanish speaker, he suffers from mental illness, that's exactly the kind of person who can get tripped up by post-release supervision's detailed requirements, and he is someone who already is connected with services, already has a strong relationship with the Osborne Association. They have assessed that he has the potential to succeed and be a productive member of society and is motivated and sincere. So,
And he would not be able to continue to work with Osborne on post-release supervision?
no, Your Honor, but Mr. Brioso is the type of person, because of his vulnerabilities, who has...
No, that wasn't my question.
Oh, yes.
Is there some prohibition on, with the post-release supervision that would preclude him from working with the Osborne Society?
Of course not, Your Honor, but the danger is that he would get tripped up and become incarcerated due to non-criminal activity, but because of his lack of education and vulnerabilities due to the myriad requirements of post-release supervision.
Thank you so much.
Thank you.
Kuza versus New York City Department of Finance.
Good afternoon, Your Honors. May it please the Court, Stephen Kuza on behalf of the petitioner. Your Honors, this is an Article 78 proceeding where petitioner challenges a finding of liability for a speeding camera ticket where he is alleged to be traveling 36 miles per hour in a 25-mile-per-hour school zone at 4 p.m. on November 17th of 2020. The larger question, larger issues that this case raises is about rules, the rule of law, and how respondents, the city, didn't follow those rules, and how this conduct deprived the petitioner of...
Is not the issue whether or not the petitioner was in fact speeding?
I mean, that...
I mean, for me, I thought that was the threshold issue.
That is...
I guess I saw it a little differently, because you should not be doing 36 miles per hour on Central Park West between 96th and 97th Street anytime, let alone 4 o'clock in the afternoon, right?
I don't disagree with Your Honor, but this is an Article 78 proceeding where what's raised here and what this court has to address is the record below and the decision of that court.
So your argument was that the cameras somehow were not calibrated, or that there was no proof submitted that the cameras were actually properly calibrated?
Correct, and that's required. It's mandated by the statute. If we look at the record that the ALJ reviewed, there's absolutely no proof whatsoever that the camera was in fact calibrated.
So we have a picture, a video, a still of petitioner going 46 miles per hour, right? We have the license plate.
36.
36, I'm sorry. We have the license plate, right, that's captured. And we have the date and time.
Correct.
What are we missing?
I mean, there were also other documents. I mean, there were technician certificates, a daily setup log, a camera log report. But the larger issue here is that in none of these documents, in absolutely none of these documents, is there a certificate of calibration or some averment or affirmation.
Why do we need a certificate of calibration when we have the photo that shows the date, the time, the speed, the plate number?
Well, first of all,
what do you mean by calibration? I guess that's my question.
Well, I mean, take a silly example, stepping on a scale. If it's not calibrated properly, it doesn't reflect accurate weight. That's the whole point. The whole point of the monitoring...
So you're saying that it wasn't 36 miles per hour?
No, I'm not saying that. I'm saying that the ALJ, when he issued his decision here, did not address that argument, which is part of the basis of an Article 78 petition. It's whether or not he had a rational basis and it was not arbitrary and capricious, and whether or not it was based on substantial evidence. The statute requires that there's a certificate...
Counsel, while the statute requires that the cameras be calibrated, is there any requirement in the statute that calibration be in the notice?
I would argue yes, absolutely.
Where is it in the statute?
Your Honor, it is, just one moment.
Why don't you look for that and you can talk about that on your rebuttal.
Sure, very well, thank you.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of respondents. So contrary to petitioner's contention, the city in fact established through prima facie evidence as required by the statute, the 2 photos and the technician certificate, the petitioner was speeding here. He wants to set aside
Did those also establish the calibration, the correct calibration of the machine?
There is no issue as to that in this case, Your Honor, because contrary to petitioner's argument, there's nothing in the statute that requires for the prima facie evidence, the initial burden of the city to be satisfied that the calibration certificate or proof that the camera was operating correctly that day be included among the materials in the notice of violation. And this panel can be, it doesn't need to concern itself with that because we satisfied our initial burden. Petitioner then had the opportunity to overcome that burden with contrary evidence, had the rights under the procedures of the Parking Violations Bureau to subpoena anyone or anything that he thought could help him with his case. If he really thought that there was an issue about—
Does that include calibration reports?
Yes, it's not only available for inspection, he could have gotten it and the ALJ could have adjourned the proceeding if they needed photos, if they needed to, see if the sign was there, if they needed to see the calibration was properly done, but the record—
So pursuant to the question that I asked your adversary, so the statute does require that the cameras be calibrated, but there's no equivalent requirement that that calibration be included in the notice?
That's correct. The camera has to be working properly, but there's no issue here that doesn't need to go in the notice, and the record actually supports that they were working properly.
And petition didn't actually object or refute that he was not going 36 miles per hour.
That's
Because
right.
what I did not understand in terms of the whole issue in terms of calibration is that he wasn't stating that he wasn't going, disputing that he was going 36 miles per hour. So therefore, I did not understand how the calibration even came into question.
Well, the camera is necessary to know the speed of the car because unlike seeing someone who's maybe turning right on a red or going through a red, you only need one stationary photo. I think the calibration is important, but here the legislature made a considered judgment that to establish its case prima facie, all we need is 2 photos of the same car and the same stationary object, and the technician trained and employed by DOT who certifies under penalty of perjury that this shows that the—
Now, the statute does say that the cameras are to undergo annual calibration checks.
That's right.
So that you could not read to also state that there has to be a record presented of the annual calibration check?
No, Your Honor, because I think it requires something that the city does, but it's not— the city is able to do enforcement actions without it being required that they sort of preliminarily prove that up. And in any event here, we have record evidence showing that it was, of course, perfectly rational for the ALJ to reject petitioner's arguments when he's trying to read new requirements into the statutes. In any event, there were a multitude of sources and a multitude of opportunities for petitioner to adduce any evidence if he really thought the camera wasn't working properly or the sign wasn't there. This court should affirm.
Thank you.
Thank you.
Yes, so just to lead off very briefly with the question, the statute does require that the apparatus be calibrated properly. It has to pass a self-test and—
But does it require that that be proven at the hearing?
I think so. I think the whole purpose of the monitoring system is to deter speeding. And we can all agree that a monitoring system is useless if it does not accurately and reliably measure speed.
That doesn't answer my question as to whether proof of the calibration was a necessary part of the prima facie case.
I would absolutely argue that it should. The statute requires it. It's mandatory language. It says that the apparatus does have to be properly calibrated in order for a violation to lay. And the larger issue, which I'd like to just briefly address, is that it's nowhere mentioned in the ALJ's decision, which is what this court is supposed to review. This is, Article 78s are an appellate vehicle for administrative agency determinations, and he doesn't mention it at all in the arguments that I raised in my initial papers.
Thank you.
Thank you.
Kamara versus 323 Pass owner.
Good afternoon. My name is Evie Kazansky, and I represent appellants 323, I'm just going to call them Pass Owner, 323 Pass Associates, and 323 Pass LLC. and I'm just going to call them the past entities. Past entities moved for summary judgment, and that summary judgment was denied. We are therefore seeking reversal based
So
on...
the whole issue is, are those interior, that the interior stairway that the plaintiff was descending? I know, was he descending or descending?
He was descending.
Descending, and he tripped and he fell,
The
right?
staircase at issue is part of the demised premises through the lease. That's clear from the record.
And the past defendants, you're out of possession landlords?
Our argument was that we were out of possession based on the lease, that the lease required no maintenance and/or repairs of the staircase, and that there was nothing in the lease to argue, as plaintiff did, that we retained any control over the space. It's a rubberized tread that was put over the steps by Cava Restaurant. Cava, by its course of conduct, continually moved and replaced that rubberized tread. And then secondarily, even if you have a right of reentry, the plaintiff has shown by their briefs and even their underlying arguments have no specific structural administrative code. They've apparently abandoned all the ones that were in the bill of particulars because it's a rubberized tread. The staircase...
So stated a little differently, it was not a structural repair.
There was no structural repair.
And even Cava acknowledged that it was not PASA's responsibility, it was their responsibility.
Yes, the whole argument by the judge and the plaintiff was that the issue of these possibility that we had able to make alterations gave us a certain amount of control that took us out of the realm of out-of-possession landlord. And we argue that, first of all, when you read those statements about alterations, number one, Cava never asked us for alterations. Number two, they had the ability to do the alterations even if the past entities didn't.
Well, the manager of Cava stated that they never informed you of any issues with the stairway, right?
That's the last argument with respect to notice, which we argue as an out-of-possession landlord, we don't even need to prove. But with respect to Cava, it's a restaurant, and the stairs connect the restaurant to the basement where their kitchen is, as a typical New York City restaurant. This court has continually found that those particular types of staircases are within the demised premises of a tenant. The tenant's responsible for them, barring any specific thing in the lease, which in this lease, no. And yes, lastly, the plaintiff himself, I want to say it's a him. If it isn't, I apologize. Cava and the PAS entities all agree that nobody ever suggested to them to come and change the rubberized tread or even told them that there needed to be the change in the rubberized tread. Therefore, we are out of possession, and we ask for a reversal.
Thank you.
May it please the court, Ian Ash for the respondent. Obviously, we're asking for the decision to be affirmed. I mean, the lease specifically required that the defendant owners review all construction work, all alterations. There's no question that in the lease itself, it says that this is
Article 7A sub I of the lease required Cava to make non-structural repairs, didn't it?
It required it to, well, it gets a little complicated when you talk about the stairs because there's a question of whether the stairs are even part of the demised premises. If you look at the definition of a premise.
But assuming it is, this was not a structural repair.
Well, there's no evidence that this was not a structural repair. I mean, basically, they took over the space. It was defined as an unfinished space. The witness for Cava was not the individual who was directly in charge of the construction. That was another individual. But she said she characterized it as almost a gut renovation of the first floor and the basement. And they present no evidence of what this alteration was. They argue that it was non-structural. They present no evidence whatsoever about what was done. Even if you confine the work to the stairs themselves, you have no evidence that they didn't replace the entire stairs, didn't replace the footing of the stairs, didn't replace everything, not just the rubber treads. And this is one of these cases where Cava is admitting that these stairs were, the moment they started open the restaurant for business, these stairs were extremely hazardous. The witness for Cava, Ms. Harvey, testified that accidents were happening on these stairs every week. They testified that those stairs had to be renovated 2 separate times after this accident because people were falling on the stairs so often.
But Kava was the one who made the repairs, and she also testified that she never reported it to the building owners.
Well, I mean, if you determine, as the court did, the motion court did, that they retained control, that they were not out of possession, first of all, there's a question as to who actually installed the treads. There's no evidence specifically as to whether or not Cava did it or whether these were installed prior to Cava taking ownership.
But I thought Kava had approval, and Kava was the one who designed the renovations.
Cava there's no evidence as to who specifically installed these stair treads. That's what the court kind of concluded also. And Ms. Harvey couldn't say, I asked her point blank, and I quote it, were the stairs part of this renovation, what was done? I don't know, someone else was handling it. They don't submit any of the construction specifications or plans. And I think consistent with this court's decision and right, I think the evidence in this case, the lease agreement, created a question of whether or not they were out of possession. And if they weren't out of possession, then you're talking about a dangerous condition that existed for months, to the point where they had to change these stairs 2 separate times afterward.
Was there anything in the record that PA's defendants ever came to the site? Because I think that she also testified that she was unaware that they even inspected or came to the site.
Well, Ms. Harvey, never went to the site until after the construction was done. So she was not, as far as after it happened, her testimony was that it was Cava. We have no evidence or testimony from the property manager or the other individuals from the ownership as to what exactly they did or didn't do. I asked Mr. Herman, who was the chief financial officer, who's responsible for maintenance of the stairs. He said, I don't know, which in the context of this lease, which basically reserves all spaces inside the building that are part of a stairway for the owner, it creates also an issue of whether or not this was even part of the demised premises. So,
thank you.
Thank you very much, Your Honor.
On the record at 665, it's clear that this staircase is part of the demised premises. It goes from the top of the restaurant to the bottom where they're making the kitchen. And the issue is because it's a condominium situation, they want to say that the words that they're using, the stairwells and stuff, they're talking about the common areas related to the areas where the condo residential part can access, if needed, the possibility of getting into the restaurant. This staircase is clearly part of the demised premises. Secondarily, the lease was signed in March, this accident's in July. Between March and July, Cava was completely in control of this space, running a restaurant. It's actually around the block, so anybody could go over there. And the rubberized treads are not considered structural defects. The rubberized treads were put there specifically by Cava because they know they were carrying food back and forth and thought that would be safer than having an actual staircase with maybe diamondized situation. So very briefly, I think the plaintiff's argument, they're attempting to make a red herring where there isn't one. The treads aren't structural. The lease has no maintenance and repairs of that staircase. It's clearly in the demised premises or out of possession.
SG and Infant versus Harlem Village Academy. You may proceed.
Thank you. Good afternoon. My name is Stuart Diamond. I'm here on behalf of plaintiffs' appellants. As the party seeking summary judgment, Mission Society bore the burden of proving on its motion that they lacked actual and constructive notice of the hazardous activity that led to the infant plaintiff's injuries.
So where is the reason to believe that there's notice of the fact that there's this so-called Drano bomb by this garbage can which had been turned over?
The only evidence, the only competent evidence submitted on the motion militates in favor of it, finding that there is notice, or at least that there's a question of fact about notice. That's the testimony.
How do you show that question of fact?
The testimony of the infant plaintiff herself, who said that she saw these two boys loading up the bottle.
Well, she did not testify that she saw these two boys loading up this particular bottle. She testified that she saw them loading up, as you want to say, loading up another bottle. In fact, she said that she saw these children pouring something into a Poland Spring bottle.
Correct.
The bottle in question apparently was a vitamin water bottle, and it was also a vitamin water bottle, which she also testified that she thought that she had discarded herself into the garbage.
If the three or four employees of the Mission Society, who everyone agrees was in the park at the time, had seen that, there's no law that says, there's no case law that says that just because it was a different bottle.
Okay, so they see two young men or two boys putting something in a Poland Spring bottle. Now what?
So if she saw it, they could have seen it, except she.
Okay, so they saw it, then now what?
Then they were on notice of a potential hazardous activity.
Why? How do you know what they were putting in this Poland Spring bottle?
Well, we don't know because they haven't produced a witness for deposition and they didn't submit an affidavit in support of the motion. Maybe they would have said, I knew exactly what they would have done. Or if I had seen it.
Well, did she say that she knew what they were pouring into the Poland Spring bottle?
Doesn't matter what she saw. It matters what they saw.
You just said it mattered what she saw.
No. Only that she saw them doing this activity. That proves that if they hadn't been preoccupied with their cell phones,
See, I don't see how you make that jump.
Because if she was able to see it, she was only.
But all she saw was them pouring some type of liquid, she says, right, into a Poland Spring bottle. She
Correct.
said she saw them pouring something.
Correct.
How do we know what, first of all, again, what she kicked was a vitamin water bottle. It wasn't a Poland Spring bottle. But again, how do we know what they were pouring into the bottle? And how would the individuals from Mission know what they were pouring into the bottle?
They may have been aware of this issue about Drano bombs. We don't know because they not only didn't appear for a deposition, they didn't submit an affidavit in support of the motion. How are we to know what they knew or what they would have discerned?
Didn't the infant's mother testify she was unaware of any issue about these bottles being hazardous? And didn't the dean similarly testify that there was no awareness of a problem with Drano bombs?
The dean worked for a different defendant.
Well,
No one from this defendant.
testimony is in the record, isn't it?
But the dean can only say what he knew and maybe what the school knew. He can't say what the after-school program knew because he didn't work for the after-school program.
But he can say what was not known in terms of this particular playground. I mean, isn't it also relevant that there's no testimony, there's a lack of testimony as to any knowledge of Drano bombs whatsoever at this playground?
We have no testimony because they didn't appear for the deposition and they didn't submit an affidavit in support
But
of the
again,
motion.
it's in the record that no one was aware of this, including the mother.
No. It's in the record that those two people weren't aware of it. It's not in the record that no one was aware of it. If they had submitted an affidavit in support of the motion saying we weren't aware of it, at least they would have satisfied their prima facie burden. We would have raised an issue of fact. But they didn't even do that. How can you possibly sustain a burden of proof on summary judgment without a shred of evidence from your own party, an affidavit or deposition testimony? It's impossible.
So they can't use the testimony of the co-defendants?
Theoretically, if the co-defendant somehow knew what they knew, theoretically.
No, theoretically that the co-defendants stated that they were unaware of any Drano bombs in the playground.
That's not at all probative of what the moving defendant knew. We didn't move.
I'm sorry, Justice Gessmer?
I have a somewhat related question. As I recall, the plaintiffs, the minor plaintiff's deposition testimony, and I believe also her 50H testimony, said that she was aware that these particular boys had caused problems of some kind in the park beforehand. Is that of any relevance?
That was testimony. I believe there was also testimony from Mr. Billups. We don't know. It's the same argument. We don't know what they knew about these two boys.
But if the mission people had known, if the after-school program had known that these boys were problematic in some way? Would that be relevant?
That would certainly be relevant. We
And
were
how so?
deprived of being able to prove that, because it goes to the propensity of these two boys to create a problem. But I don't even think it requires that much, because there was more direct evidence available to them of being able to see these boys actually loading up the bottle if they hadn't looked at their phone. All of that evidence is undisputed, and all of that evidence militates in favor of the plaintiff.
Thank you.
May it please the court, my name is Dan Ratner. I represent the after-school program
So
respondent.
your first argument was that there was no duty to supervise because she was not actually in this after-school program. But did you submit anything to support that?
Well, we submitted the attendance records. We submitted her own the student's own testimony, where she said that she sort of never went inside the building and met her friends at the park. So
She also testified that she was.
hadn't gone to the program that day?
I don't think she testified quite that far, Your Honor. She actually kind of was trying to say that it was informal and sometimes she wouldn't check in, but she sort of regarded herself.
Counsel, as I read her testimony.
Proof on this motion for summary judgment.
I'm really sorry I didn't get
How did you meet your burden of proof on this motion for summary judgment? What satisfies your burden?
We submitted the student's deposition testimony. We submitted the school employee's deposition testimony. We submitted attendance records, incident reports, all of that. But
Have you submitted anything on behalf of your employees?
No, we didn't, Your Honor. No, we didn't. Except
So are we supposed to accept Billup's sort of testimony that they knew nothing about this Drano bomb, that the school knew nothing, so we're supposed to impute that lack of knowledge to your client?
well, I would just point out that Mr. Billups was the person who they went to get to come down to the playground.
Right, that doesn't answer my question. My question is, are we supposed to impute the school's knowledge to your client's knowledge?
No, we're not. It's just a piece of evidence as part of our motion. But I would like to say.
Well, one
But let me
second,
ask-
counsel. Let Justice Gesmer ask a question, please.
So you said that you had submitted the attendance records. I looked really hard and couldn't find any affidavit by anybody who authenticated the attendance records or established a business records foundation for it. So I don't really see how we can rely on those attendance records. Maybe you could show me where in the record you established a foundation?
I cannot accept.
Okay, so why should I look at those attendance records?
Well, I would say to you that they are not an admissible form, but obviously they can be easily made to be an admissible.
Oh, but they're not, it's not our job to make them admissible,
I
counsel.
actually
That's
think-
your job.
I
So why should I look at the attendance records? Maybe if you can help me out here, I'd be happy to look at them, but
You don't have to affirm this order, and I'll
But
just.
you also said you relied on the child's deposition, but in her deposition, she said very clearly that she was at the after-school program that day, didn't she?
Right, and I was asked what we relied on. I also would like to say that the deposition testimony of the child, she very clearly stated that she kicked over a bottle that she thought was her own bottle that was among a whole bunch of bottles that were right near a tipped-over garbage can.
Okay, but-
How it would be foreseeable?
But
in
she
that-
also testified that she'd seen these boys who had caused problems before putting something into bottles, and she also testified that your employees were not looking at the children or looking at the playground, but only at their phones.
She
Doesn't that
testified-
raise a question of fact as to whether there was adequate supervision being provided?
I don't believe so, Your Honor.
So
because-
how do you establish there was adequate supervision? Maybe you could point me to the part of the record that shows that your client's employees were supervising the children in the playground.
I am arguing that the incident in question was not foreseeable.
I asked
so-
you if you could tell me where in the record it shows that your employees were supervising the children in the after-school program.
Our motion was not based on that, Your Honor. We did not argue that.
So you don't, excuse me, am I correct then? You don't show anywhere in the record that your employees were supervising the children?
That's correct. Well, we argued that this child was not under their supervision.
Well,
because
I
he was
understand,
not in
but
the
assuming that since you didn't establish, since I shouldn't look at the attendance records, and since she said she was in the program that day, are you agreeing that that there's nothing in the record that shows that your employees were supervising the children in the playground that day?
I am agreeing, but I'm not conceding that's a basis for reversing this
Okay.
order, Judge. I
Thank you.
mean,
So what, in terms of foreseeability, what was your argument in terms of foreseeability?
These children that were apparently allegedly involved in this prank were on another basketball court. They were pouring something into a bottle. The kids in the program were in a separate group at a separate basketball court. She got done playing basketball because she didn't see what they were doing, the whole thing, because she then went and played basketball. And then after she was done playing basketball, she turned and walked off the court, and she sees her bottle on the floor, kicks it over, and thought it was her own. So that's why I'm saying it could not be possibly foreseeable.
Counsel, where in the record does it show that the children in the after-school were playing in one part of the playground and that the boys were in a different part based on on anything from your clients?
No, from the child's own testimony, Your
I
Honor.
see.
I'm sorry.
And where is that in the record?
Doesn't show that.
Just bear with me for 1 second. I'm sorry. She testified that she saw two boys on the other side of the park put stuff in a Poland Spring bottle that was a different bottle from the vitamin bottle. The group of students was huddled on one basketball court. That's at page 319 through 322 of the record. And the others in the after-school program were on a second basketball court.
Well, she says
Where does it say
group of students was huddled. Well, she says testified she saw two boys on the other side of the park put stuff in a Poland Spring bottle that was a different bottle than the vitamin water bottle, and that the group of students were huddled on one basketball court while SG and the others were in the after-school program were on a second basketball court.
Right, and I believe that's probative of my argument that it's not foreseeable, because even if these children were not being adequately supervised, and by that I mean the kids in the after-school program, I'm not sure how we could jump to the conclusion that they should have been, looking at the other basketball court.
But what about the
Just pouring
fact that
something
she testifies that she went over to the supervisors or whatever from the mission program who were on their cell phones, and she jokingly said, you guys are on your cell phone, jokingly tells them to get off their cell phones.
That's a piece of evidence that we cannot get around. It's there, no doubt about it. However, I still think it's not foreseeable.
How did you rebut it?
I would say that it's still not foreseeable, Your Honor.
Well, counsel, we don't know what your client knew with regards to these Drano bombs, right? So wouldn't it be a different circumstance if we had information that your client was aware of something to do with Drano bombs, and then you have this report of kids pouring something into a bottle? Wouldn't that change everything here?
If it was something that they could have readily observed, I suppose.
Well, if they weren't on the phone, probably they could have. The problem here is that we don't know what your clients knew or didn't know. Isn't that right?
That is correct, Your Honor.
I think Justice Friedman has a question.
You asked it already.
Oh, thank you, counsel.
Thank you, Your Honor.
It's about the foreseeability.
Counsel just said that the testimony of the infant plaintiff is something they can't get around. They easily could have gotten around it. They could have submitted forget about the not appearing for the deposition. They could have submitted their own affidavit. They submitted evidence proving that there is a question of fact. The infant plaintiff testified on both of these issues about her regular attendance, her attendance that day, and also about the foreseeability of this incident. It's very reasonable for this or any court or any jury to assume that having been faced with that testimony, they're not putting in an affidavit saying, no, it's not true. We didn't have notice. This was unforeseeable. She wasn't attending the school that day. Then at least they would have satisfied their prima facie burden. But it's reasonable to assume that since they didn't put it in that affidavit, the reason is they couldn't have put it in that affidavit because those employees couldn't honestly contradict what the infant plaintiff testified to. Is that true? I don't know. But they've left us there was no basis upon which the trial court could have decided any of those issues. And to the extent that there was any evidence, it all militated in favor of the plaintiff. The infant plaintiff's testimony on all these issues was undisputed. Thank you.
Thank you. People v. Leroy Gordon. Oops.
May I proceed? Good afternoon, Your Honors. Megan Liu, Pro Bono Counsel alongside the Legal Aid Society on behalf of the appellant, Mr. Leroy Gordon. Mr. Gordon has been sentenced to 9 years for taking items such as slippers, coins, credit cards, and electronics. The sentence is excessive.
Where did he take
disproportionate.
those items from, other than the electronics, which I think he took from the New York Public Library? But where did, oh no, he took the electronics from the apartment as well.
There are 4 incidents at issue here, Your Honor. 2 are residences, which were vacant. Nobody was home. There were...
Well, were they vacant, or was it that no one was home? Was that first apartment vacant? I thought that it was occupied, but there was no one home at the time.
There was no one home at the time. when
Right,
Mr.
and you
Gordon
make
took these
much
items.
of that in your brief. You say this is to his credit, that he, that he burglarized the home a little after midnight, knowing that no one would be home. So he knew no one would be home because he, what was the term? Cased the joint previously, so he knew the routine of the occupants of the apartment. Is that what you're saying?
We don't have evidence in the record as to the state of his mind.
So it was actually fortuitous, at least for the occupants of the apartment, that they weren't home at the time that he burglarized it, right?
9 years for taking items, Your Honor, such as slippers.
Well, it's 4 burglaries, right? Is that correct?
That's correct, Your Honor. Other defendants have received lesser sentences for much more serious offenses.
And these other defendants were also on parole at the time of at least one of the burglaries, and these other defendants were also, was not their second violent felony?
Yes, Your Honor. We cite cases where there are similarly situated defendants, defendants who commit more serious offenses, second felony offenders.
So your argument is that we should look at, your argument is that we should reduce his sentence because compared with other defendants who were similarly situated, if that's at all possible, he received a higher sentence.
Additionally, there are many mitigating factors this court considered. Nonviolence is a very important one. We have, this court has considered nonviolence to be a mitigating factor when considering the reduction of
Burke 2 is a violent felony, right?
It is classified as a violent felony, but in this case, no violence occurred. In one case of confrontation with a security guard, Mr. Gordon actually dropped the crowbar he was holding.
Right, he had a crowbar, and he
dropped it and fled, which shows the absence of violence here. Additionally, there are other substantial mitigating factors. This must be contextualized within the context of his life. This court also does consider whether crimes are crimes of necessity when considering the reduction of a sentence.
And how do you show that, I understand he was homeless, but how do you show that it was a necessity?
For instance, in one case where he took a credit card, he immediately went to a Capital One bank and attempted to withdraw $300 from the ATM, evincing a need for quick cash.
Well, this is a credit card he took from the apartment that he burglarized, right?
If a crime is a crime of economic necessity, that is a mitigating factor this court can consider.
And so the Xbox, he was going to sell that, right? He wasn't going to play any games on that one, right? And then he goes into the commercial, the commercial location. That's the one with the crowbar. And then he goes into another apartment on East 50th Street and taking the laptop, camera, and credit card. Then he's found in the New York City Public Library on 40th Street, 42nd Street, whatever. And he's found with 2 laptops, right?
The frequency of incidences is a consideration here, but I'll note that if Mr. Gordon were to reoffend upon release, he would be convicted as a mandatory persistent felon and in for life. He understands this. This is a powerful deterrent that is not minimized.
He's about 35 years old, 34 years.
He's currently 38, Your Honor.
30 when he commits these 4 burglaries in the space of 6 months, 2 of residential apartments, 2 of commercial premises.
He's in his early 30s. He has much of his life ahead of him. A sentence reduction to the minimum of 2 years here will not minimize the deterrent.
And these are not the only crimes in his background, these 4 burglaries.
And that was already accounted for in the sentencing.
What was he on parole for? I don't recall.
That was the attempted assault in 2013, Your Honor. And
so I'm sorry, so you're asking us to reduce the sentence to 2 years?
To the minimum of 7 years, Your Honor, with the minimum release supervision of 3 years. Even with the reduction, this is a substantial amount of time. He's already served a substantial amount of time, and we think 9 years is excessive in this context. Thank you.
May I proceed? Good afternoon, Your Honors. Jennifer Cavallas for the people. May it please the court. Defendant's excessive sentence claim is foreclosed by his
Counsel,
valid...
the waiver of right to appeal here, the judge that presided over this matter has been reversed in the past for the ineffective waivers. How's the waiver in this case different from those cases?
Your Honor, the waiver here is entirely different. In the cases, the precedent cases that defendant cites, Judge Ward used words like, if you gone to trial, in this case, you would have the right to appeal. In this case, she merely used trial as an example by saying, for example, had you gone to trial, you would have had the right to appeal. She remedies that by saying, now, by waiving your right to appeal, you're telling the higher court that they don't have to review what was done below. The word below indicates all things that happened below, including the plea proceeding before the judge at that time.
And why would that be clear to a defendant, that below means what you just said it says?
Well, it's clear to the defendant what was going on because he was under advisement of his attorney right there, and when he signed the written waiver of appeal, he indicated that he had spoke with his attorney, that he understood the nature of the waiver and the right that he was giving up. So in the totality of the circumstances, it's clear that defendant understood the nature of the waiver and how it functioned. Notwithstanding the waiver, defendant's bargain for sentence was lenient in light of the nature and number of his crimes. As previously discussed, the imposed sentence was precisely what defendant bargained for as part of a valid plea agreement. Defendant committed a string of burglaries over a period of 6 months in which he broke into people's private homes, stealing thousands of dollars of items, including multiple laptops, cameras, phones, coins, and ransacking their apartments where...
But none of the crimes involved any type of violence. And when he had the crowbar and was confronted, I guess, by the security guard or the doorman, he dropped the crowbar. So should that not be taken into consideration?
No, the matter that the fact that he did not commit a violent act is irrelevant under the sentencing because the legislature indicates that burglary in the second degree is a violent crime for the propensity of violence that is inherent in going into somebody's home and stealing things from their home. Additionally, if he did commit a physically violent act, he would have been charged with burglary in the first degree and sentenced accordingly under that higher, more serious crime. Additionally, the factors that defendant cites do not warrant a reduction in his sentence. Specifically, the court was fully apprised of his mental health status and homelessness through the virtue of the pre-sentence report, and that was before the sentencing judge at the time. Additionally, defendant discusses that there are similarly situated defendants who were sentenced differently. Those cases are entirely distinguishable from the case here. In the precedent cases that defendant refers to, the cases just are very different. Either the defendant had a lower intervention in the crime, they were either co-defendants, the defendants were very young. Here, Mr. Gordon was 34 years old, not young by any means. He has a lengthy rap sheet, and he did this over 4 times over a span of 6 months. Recurring behavior that was not crimes of necessity, being that he stole thousands of dollars over a period of time.
Well, that's the other thing. These are property crimes, right? They can be seen as property crimes. It's not 9 years, a considerable period of time for the commission of property crimes.
Yes, this is more than just a property crime. Seeing it as just a property crime completely discounts the experience of the victims who had their private homes invaded and ransacked through their personal belongings and their drawers. It completely discounts the fear that is inherent in somebody.
Burglary in the second degree is not looked upon as a property crime.
Yes, it's a violent felony under the penal law, which shouldn't be discounted for the fact of the matter that now he's a violent predicate felon, showing that he has a propensity to keep causing violent crimes. And for those reasons, 9 years is very lenient when all these sentences were to run concurrently, all 4 of these burglaries.
What was he facing even on just one burglary?
On the top count, burglary in the second, it was 7 years, a minimum of 7 and a max of 15. And all of these cases were to run concurrent, so he got just 2 years over the max for 4 burglaries altogether. We ask that you affirm if there's no further questions. Thank you.
Thank you.
Your Honors, the appeal waiver here was invalid. I will highlight that this court has previously found almost identical waivers by the same sentencing judge insufficient for the same reasons we submit this appeal waiver is invalid. For example, this court in Braithwaite rejected the language that had you gone to trial was simply an example and found that mischaracterized
Counsel,
the
in
appellate
that
right.
case, isn't what the court rejected the language that by pleading guilty, you're giving up that right too, thereby concluding that the judge conflated the trial rights that he's giving up with the appellate rights?
That occurred here as well, Your Honor. And here, most notably, the judge also impermissibly stated to Mr. Gordon that he was required to sign the appeal waiver and did not explain if that was the court's intent, that the waiver was part of the voluntary bargain for plea. And in addition to what you just said, the confusing colloquy, the way it was set up, the separation of the discussion interspersed with unrelated discussion. We cite cases in our reply brief where the plea colloquies were, the waiver colloquies were identical and rejected, and we're happy to give that to the court if required.
Thank you so much. City University versus Utica First Insurance. Justice Rodriguez is recused on this matter.
May it please the court, Michael Kazores from the law offices of Eric D. Feldman on behalf of the plaintiffs' appellants, City University of New York and Stalco Construction. The issue in this case is whether Utica First disclaimer based on the employee exclusion was untimely as a matter of law. Our position is that the disclaimer issued on March 18, 2016 was unreasonably late under insurance law 3420D, given that the tender was admittedly received by Utica First on December 28, 2015.
Yes, but the tender by Travelers did not disclose any critical information that would have given Utica a heads up. I mean,
Well,
as I read Mr. Williams' affidavit in the record, he simply said, yes, Devlin, it was an accident, there's no lawsuit, and again, I'm cutting to the chase a bit, it was more like a monitor type situation. It wasn't a real situation where, you know, this is the kind of heads up that you should really do research. And parenthetically, didn't Utica investigate the matter?
Well, to answer your first question, Your Honor, admittedly, I mean, Travelers didn't know much about the accident. The accident had occurred 6 days earlier, but we did know the date. We knew the injured claimant. We knew his employer. And there was a tender based on the anticipation that there was going to be a lawsuit. And
yeah, but wasn't Mr. Devlin's resume that was part of their investigation has him working for some entity that has nothing to do with this?
No, Your Honor. The resume was in his employee file. It was the resume that he submitted to AIM Builders at the time he applied for the job. It wouldn't already contain his employment with AIM. It was the resume that he submitted as part of his application for employment there. There was no reason for an investigation where the sole basis for the disclaimer was that he was an employee of AIM. The fact that he was an employee of AIM was stated in the tender letter. There was no need for any further investigation. And in fact, the disclaimer letter didn't even mention the investigation. It simply disclaimed
There may
coverage.
have been other reasons for disclaiming coverage at that point, and they don't know. I mean, it's not like they've been even been given a complaint. And what is the outlook on whether there should be piecemeal disclaimers? Are they permitted to wait to find out what the situation is so that they can provide all their bases for disclaiming coverage?
No, Your Honor. The case law is clear from the Court of Appeals that you can't wait for an investigation and to acquire other information as a basis for a disclaimer when you already know at least one basis for the disclaimer at the time of the tender. The case law is clear that you can't conduct an investigation to find other reasons to disclaim when you already have a reason to disclaim based on the tender itself. And, the case law is very clear on that. It's the Court of Appeals cases, this department cases. There was simply no need for an investigation. They relied simply on the employee exclusion, and the tender letter said that Mr. Devlin was an employee of the Utica First Named Insured. 86 days later, there's a disclaimer, and the disclaimer is based on the fact that Mr. Devlin was an employee of AIM Builders. And they knew that on the day that they received the tender back in December 2015. That is an unreasonable delay as a matter of law under 3420D and the case law of both this department and the Court of Appeals. Thank you.
Thank you.
Good afternoon, Your Honors. My name is Lester Channon from Farber, Brox, and Zane for Utica First on this appeal. As far as the disclaimer goes...
The letter tells you that he's an employee of AIM.
Yes.
You know that there's an employee exclusion. Why didn't you, just about at that very point, have to disclaim coverage?
Well, first of all, it's not based on personal knowledge. It's based on, they say, based on allegations that they don't specify where they come from. There was no complaint, so I can't understand what the allegations they might have been referencing were from. But in any case, they certainly don't say that it was in the course of his employment. They said, even the way my adversary was arguing the case, if they're an employee of AIM, which was uncertain, especially given the resume, then ipso facto, the exclusion applies.
The letter did say, did it not, that he had been working on a masonry wall when he fell?
We had reason to believe there was a possibility that he was an employee injured in the course of his employment, but we were entitled under the case law to look into that. They had no personal knowledge of it. When we spoke with them after they delayed, I don't know, was it 17 days in getting back to us? And we spoke to them and said, we have no info in our investigation file. Okay, now that did...
Well, why would not the fact that he's working on a masonry wall when he falls, why would that not be sufficient to establish that he was an employee?
It's an assertion, not based on any personal knowledge, that we were entitled to explore a little further, especially considering the fact that they said that they had no info in their investigation file. So we had no confidence.
But it also said that no lawsuit had yet been filed.
Yes.
So again, would that not lead you to believe that,
That what?
that he was an employee and that perhaps there was going to be,
I don't
possibility?
I don't think the fact that there was no complaint filed could lead us to believe to any inference as far as employment or non-employment goes.
But if you believe that you needed to explore a little further, why did that take 86 days?
Well, first of all, a fair amount of the delay was the result of the traveler's own failure to get back to us on a number of occasions. Additionally, we had trouble getting a hold of the plaintiff or getting him to give a statement concerning the events, and one of the issues was the resume that we took it at face value. We didn't know.
I mean, but taking things at face value, you get a letter which says he's an employee of AIM and he fell while working on a masonry wall. Doesn't that immediately tell you, well, he falls right within our employee exclusion?
We had a indication. I mean, I do cite case law where they say that an insurer is entitled to explore, to confirm information alleged in a non-personal.
But this is all information in your favor. I mean, that takes you off the hook.
I have a hearing disability, and with a mask.
I'm sorry, but this is all information in your favor. They're telling you, and they're asking you for coverage. They're telling you he's an employee. He fell while working on the job.
Yeah,
we don't cover that.
We had to, I mean, we felt that it was the responsible thing to do, to just fire our guns off in a disclaimer. It might have been premature. You know, we're acting responsibly, trying to get some of the basic information. A lot of the delay was the result of travelers saying they didn't have information, and also they're saying, don't worry about it.
Well, that's
We
unusual.
just need to monitor it.
That's unusual for an insurance company, but kudos. What insurance company was that?
Utica.
Yeah, I know. I'm going to go to Travelers from that one.
Your Honor, these dates are very important, and they go towards what my adversary was just saying. The tender letter was on December 23rd. Utica First has admitted to receiving the tender on December 28th, 3 days later. In their own papers and in the record, they say that their claim rep from Utica First spoke on the next day, December 29th, with a representative from AIM on the telephone and discussed the accident. A week later, January 5th, 2016, Utica First's own investigator had a face-to-face meeting with AIM representatives. And at no time did anybody say to the investigator or to Utica First, hey, Mr. Devlin is not our employee. They knew by January 5th, at the absolute latest, that Mr. Devlin was an employee of AIM because they had spoken to AIM on the telephone on December 29th. They had a face-to-face meeting with AIM representatives on January 5th. And they still waited until March 18th, 2016 to issue a disclaimer letter. That letter should have been sent out in December or at the very latest, January 5th, 2016. And to do so in March, mid-March, is untimely as a matter of law. And that's why it should be, the decision in order of the Supreme Court should be reversed.
Thank you.
Thank you.
Atara versus Masaryk Towers.
Good afternoon. May it please the court, my name is Lauren Donnelly and I represent the appellant in this matter. In this case, the lower court improperly dismissed the third-party complaint against plaintiff's employer. First, at the outset, it should be noted that Mr. Itera passed away during the summer, and while the plaintiff has submitted a letter advising the court and the parties of the death, none of the death certificate has never been provided, although it's been demanded. Nevertheless, we respectfully request that the order dismissing the third-party complaint be reversed and that the award of costs to Centennial be vacated. In this regard, this was a pre-answer motion to dismiss the third-party complaint which asserted claims of common law, contribution, indemnification, contractual indemnification, and breach of contract for the failure to procure insurance. As it relates to the contractual indemnification claim, Masaryk clearly has a cognizable claim for contractual indemnification against Centennial, and it should not have been dismissed pursuant to CPLR.
So how would Centennial be liable for or be responsible for the latter?
Okay. If you look at the indemnification provision, there's two different scenarios where it would be obligated to indemnify Masaryk. The first is where any injury or claim arises out of, in connection with, or as a consequence of the performance of the services.
Right.
Okay. The second, that does not have a negligence trigger. And we know, this court is well aware, that the arising out of language is very broad.
So as to that first section, you're talking about the negligence in terms of the upkeep of the ladder, is that correct?
I'm not saying that it relates to negligence at all. That section right there, the claim must arise out of, be in connection with, or a consequence of the performance of the services. Mr. Itera was an employee of Centennial. They were performing services at the time of the accident. In contrast, the second portion of that indemnification provision says, and/or Centennial will defend or indemnify Masaryk for injury or any other claim arising out of or connection with the acts or omissions. That's the negligence trigger. The first
You can't get indemnification for your negligence, but you could get indemnification for something that Centennial's employee may have done negligently.
Correct. And the basis of this is a pre-answer motion to dismiss. We were not allowed to conduct any discovery, explore other theories, take depositions of Centennial's employees, and it should not, definitely the contractual indemnification claim should not have been granted.
But isn't it of some moment that that the resident superintendent, Mr. Vasquez, said that he knew nothing about maintaining or repairing an exterior metal staircase and believed that Centennial had no obligation to maintain or inspect the staircase. So why doesn't that go to the suggestion that you're in fact seeking indemnification for your own negligence?
We're not seeking indemnification for our own negligence. It doesn't have to rise out of, in the first portion of the indemnification provision, it doesn't have to relate to the acts or omissions of Masaryk. And also,
Is it possible, when this goes to trial, that a jury decides that Masaryk was negligent in the way it maintained its staircase, but Itera, in terms of this contractual indemnification which you're seeking, that Itera was also to some extent negligent or in failing to observe the situation? In
Or
other words,
Centennial,
there could be an apportionment of fault between Masaryk and Itera for purposes of your contractual indemnification.
Correct.
You can get contractual indemnification from Centennial to the extent that it was caused by Itera's negligence.
correct, and the indemnification provision has the saving language to the fullest extent permitted by law. And just in terms of the breach of contract, failure to procure claim, they did not meet their burden on a motion to dismiss, even if this was a motion for summary judgment, which it was not. They did not provide a certified copy of the policy, an affidavit, and the lower court just missed it on this one. And so
Thank you. You have time on rebuttal.
Thank you, Your Honor.
Alexandra Robbins from Centennial Elevator Industries, Kaufman Dalwich Bullock. May it please the court. The contractual indemnification provision specifies that indemnity is available as it relates to the scope of the contract. The contract is one for elevator maintenance services. The position of Masaryk is that their contractor, their elevator maintenance contractor, should be their general liability insurer for their staircase, which is really not possible. The reason, additionally, that we know that the contract does not provide indemnification is because it cannot. Masaryk is the property owner. There is no way around it. They are responsible for rusted conditions of their own stairs. Centennial comes, visits, services the elevator, and leaves. That's the extent of the relationship. A party cannot be indemnified for their own negligence.
But in terms of this being tried, isn't it possible for someone to say, well, yes, the staircase was no good, but Itera, in the way he approached that bad staircase, bears some responsibility too?
Your Honor, to the plaintiffs...
I mean, what you're asking us to decide now is, as a matter of law, that Masaryk is 100% liable for that staircase. And whatever happened on that staircase, however the accident came about, they bear full responsibility, when on a pleading motion, we have no idea exactly how that accident came about.
You don't have to determine that, Your Honor. Mr. Itara's comparative negligence is not at issue and does not affect the analysis.
Why would it not affect the analysis in terms of indemnification?
Parties are free to allocate risk between one another for the acts of third parties. When there's just two parties, they're each responsible for their own
But
negligence.
how does Centennial become responsible for Mazurik's own negligence?
Centennial cannot be responsible for Mazurik's own negligence, and that's why contractual indemnity is precluded as a matter of law.
How do you reconcile the argument made by your adversary that part of the contractual language was arising out of the work? So let's play it out a little bit. Mr. Itara was climbing the staircase to go to the elevator room to do the work. And he was injured arising out of the work. I mean, the plain language would arguably suggest that the first part of the language of that provision should arguably entitle Masaryk Towers contractual indemnification, putting aside what my colleague is raising, the possibility of comparative negligence that Mr. Itara may have rushed up with greasy hands, didn't hold on to the bar. I'm just saying it's a pleading motion. So how do you reconcile that?
Understood. When a contractor falls through a rusted staircase, the accident arises out of the failure to maintain the staircase. Mr. Itara being at the property is simply the circumstance under which the accident occurred. It's not what gives rise to it, right? Consider a difference between...
Is that an accurate way of portraying it, or was Mr. Itara there because he came to work on the elevator for Centennial?
Mr. Itara was there because he went to work on the elevator for Centennial. That's no more an arising out of type of fact than the fact that Mr. Itara was born in the first place. Thank you.
Thank you.
Good afternoon, Your Honors. Brett Nomberg for the plaintiff. Two things quickly. Mr. Vasquez testified, the superintendent, that Centennial Elevators employees do not maintain the exterior stairways or perform safety inspections and did not have any role in causing or contributing to the stairway step coming off. He also testified that he was the only person responsible for maintaining the stairs. As to the comparative negligence of my client, he testified, so we know what he said. Nothing's going to change at trial, Your Honor. It's only going to be his deposition testimony admitted. And all he testified to is that he's walking up a stairway and the metal stairway literally falls underneath him as he steps on it. You make decisions all the time whether or not somebody's comparatively negligent or not and rule on that. There's no way that there could be...
On a pleading motion?
I'm sorry?
On a pleading motion? We do that all the time?
All the time, I could say that you can decide that. And given that there's no testimony of surprise at the time of trial, nothing's changing. Read the testimony, Your Honor. You will not find any evidence of comparative negligence on the behalf of my client simply walking up a stairway when the rusted hinge and rusted stairway fell through because after 20 years they decided they're never going to maintain that, even though they know it needs to be maintained, even though they know it rusts. So they have notice, they have actual notice, but they just don't do anything about it. As far as the other issue, even though I don't have any boat or game in this, let me address it anyway, about the indemnification. The indemnification language in the contract talks about, yes, about related to the scope of the contract. You have to read the end of it, the scope of the contract. The scope of this contract concerns elevator maintenance, not stairway maintenance. They could have, and there's a case I cited, they could have had an all-encompassing indemnification language that anybody falls on the property, God bless you, you're going to pay for it.
But I thought he had to ascend the stairs in order to maintain the elevator, in order to service the elevator.
I'm sorry, I didn't hear you.
I thought he had to go up those stairs in order to service the elevator.
You also have to enter the building, Your Honor, and if somebody enters the building and this roof falls on their head, I would hope that you're going to not find liability there. If they were in the actual building, in the elevator control room, and the roof fell on their head, same thing. But they didn't even make it. He didn't even make it there. So whether it's a stairway going up to the elevator control room whether it's a stairway, going into the elevator, whether it's anywhere, whether it's just walking on the property. You can't just, that's just not what they bargained for. That's what you have to look for in the indemnification language. Thank you.
I just want to point out one fact, and the council, both council have said that it relates to the indemnification provision, relates to simply the scope of the contract. That's an incorrect statement. I would suggest that you please look at A103, which contains the indemnification provision. The indemnification provision that I'm relying, the portion of it that I'm relying on, says, including the loss of use thereof or any claim arising out of, in connection with, or as a consequence of the performance of the services. The second portion, which they're relying upon, which has the acts or omissions trigger, relates to the scope of contract. And for the reasons that set forth in my brief, we ask that the order be reversed and that the order or the award of costs be vacated. Thank you.
Thank you. Thank you both. All three of you. Ladder Capital versus 1250 North.
Good afternoon. May it please the court, Arash Baral of Blank Rome, representing the appellant 1250 North SD Mez LLC. We're here because there would be a profound injustice if the lower court's ruling is affirmed. The lower court in this case essentially held that despite there being a, quote, viable argument as it relates to the merits of the case, end quote, if a lender declares a default, even when there is no default, even when there is a question of fact as to whether there's a default, the lender is essentially immune from liability. It has no risk. It could, and after that, it could proceed to take an asset and then sue for a deficiency following the sale of an asset, and even then, the borrower cannot sue for damages. That ruling cannot stand. It must be reversed. The simple fact of the matter is that the lower court misinterpreted Section 11.12 of the loan agreement. Per Section 11.12, it clearly applies, per its own terms, in any case where, by law or under the loan documents, lender or such agent, as the case may be, has an obligation to act reasonably or promptly. That language was omitted from the respondent's brief. But that's where...
That might cover the claim, your claim that the defendant, that plaintiff didn't act reasonably in denying consent to the change in the control.
Change in management, yes. And we would concede as to that claim.
That part of the counterclaim.
As to that part of the counterclaim, we would concede.
But as to the part of the counterclaim that claims that they should not have commenced a foreclosure proceeding, that does not fall within the language of 11.12.
Absolutely.
And these being sophisticated parties, wouldn't you have expected that if you meant to bar that sort of a suit for an incorrectly commenced foreclosure proceeding, you might have specifically put that in?
Well, I would argue that it is specifically in there because you have provisions in this agreement that get into the
11.12.
Well, 11.12, right. 11.12 has to be read in context with specific provisions in the agreement that speak to situations and circumstances where the lender has to act reasonably or promptly. We set forth several examples in our briefing to the court where, for example, section 4.1.7e, it says, lender shall have the right to approve each annual budget, which approval shall not be unreasonably withheld or delayed. That unreasonably withheld or delayed language appears everywhere where the lender is seeking to attempt to control actions of the borrower. It doesn't apply with respect to situations where the lender is trying to enforce its remedies. Where it's trying to enforce its remedies, such as the event of default provision, it's very clear. The lender has its own discretion. It says, per its own discretion, sole discretion, it can declare a default. It is only in these other circumstances where the lender is attempting to control the borrower, where it has to act reasonably or promptly, and that's where Section 1112 applies to those circumstances only. It does not and cannot apply to situations where there's a breach of contract claim with respect to a act by the lender to declare a default that we argue was not a default, or at least there's a question of fact as to whether there's a default. We are here on a motion to dismiss stage. There was no discovery that was been allowed, and the court below actually observed that there is actual merit to this case. It just misinterpreted Section 1112 to the claims that we've asserted in this case as to the fact that we don't believe there's the defaults that the lender declared were righteous or proper. And as to shortly as to the good faith and fair dealing claim, we don't believe it's duplicative. We're going to stand on the briefing on that. It's pretty clear that the lender here, as Your Honor mentioned, the lender here was doing business with the 80% owner, which is my client. They knew that the 80% owner ultimately was controlling the ultimate decisions of this project and of this transaction. They unnecessarily and without right sought and obtained $1 million in pay downs over the course of a year. So it is to those actions we believe that there's been a breach of the implied covenant of good faith and fair dealing, and those claims should be allowed to proceed as well. Thank you.
Thank you.
Good afternoon. I'm Mitchell Burns for the guarantor appellants. I have a very limited issue to discuss here, which is whether or not there was an event triggering recourse to the guarantors. We agree on most things. The documents are acknowledged, not disputed. The only real issue for my clients is whether or not there was a transfer triggering recourse. Transfer is a defined term. For there to have been a transfer of an entity triggering recourse, it had to be a transfer of a restricted party. Now, this isn't the case, the typical case where a lender comes in because it hasn't been paid. The loan here was performing. The lender, for whatever reason, decided that it would call a default and foreclose on the property, which was essentially, in the end, a hotel in San Diego. Because it said that there was this transfer, which turned out to be of an entity in the ownership stack of the minority investors. PHRI is the name of the entity that was transferred. The only issue here is whether PHRI is a restricted party. Now, restricted party is a defined term. There's a whole list. You can get very confusing, worse than a Tolstoy novel, to figure out these entities. And if there's confusion, I would always refer you to the organization chart at page 160 of the record. That sort of lays it out. But essentially what's going on is that the lender's claim is that PHRI controlled one of the listed restricted parties and therefore is itself a restricted party because it was the day-to-day manager. And the disagreement is over a provision that occurs in an operating agreement that governed the operation of the business. And what that operating agreement is, it's an operating agreement basically between the 80% majority partner, which is named OCOAST, and the 20% owners who are affiliates, minority investors who are affiliates of this PHRI entity. And under this operating agreement, PHRI is the day-to-day manager of the hotel business. But in that operating agreement, there is a provision that's not unstandard in these sorts of arrangements. It basically says
There were some things that they were not permitted to do, right? Or at least that without consent.
There's a whole
24 things?
24 major decisions.
24 things. I basically quoted them all
Right.
in the reply.
Isn't that, you sought to dismiss, but isn't this really ambiguous at this point to the action with no discovery?
Well, here, what I would say, Your Honor, is that there is no discovery that's going to illuminate the issue that's before you. I can understand why Justice Reed decided that perhaps discovery, it often does, the problem kind of kicks off the road if you let discovery go forward. But in the end of the day, the issue here is a status question, not a history question.
Is it ripe for a decision
Yes.
as a matter of law?
Yes, and the reason is it's a question of what the power of the manager was under the agreement.
Well, one
And that's
issue
clear.
was, we were talking about the 24 major decisions, right? So one issue as to that was whether consent was needed or consent was not needed?
Yes.
Right. So would discovery not illuminate whether consent was needed or consent was not needed?
No, it's clear in the document. The document says, and it's the agreement's in the record. What it basically says is to do any of these 24 things, hiring or firing your accountants, entering into contracts, doing financings, handling litigation, to do any of these, basically anything important to the business, you had to get, that was under the control of the majority party. You had to have his consent to do any of this beforehand. So it's absolutely clear in the documents. Discovery, put it this way, this is a loan agreement. There was a transfer of this entity.
Is it clear who has control of PHRI?
Yes. And that doesn't matter. The question here is not who transferred PHRI and what were they acting properly or not. The only issue is we would acknowledge, there's no dispute, that if PHRI is a restricted party, the transfer here triggered recourse, could have been a default under the loan agreement and triggering recourse. That's not the issue.
Thank you.
Good afternoon, Your Honors. Brad Gardner of Polsinelli for Respondent Ladder Capital Finance. I think it's relatively straightforward to me. The Supreme Court got this right. He gave us a 25-page thought-out decision. He considered all the arguments that opposing counsels made. He gave them, as noted in his opinion, the inferences to which they were entitled with respect to the language in their own counterclaims. And he decided not that Section 1112...
So what supports in these agreements your claim that the declaration of a default is something which is not an improper declaration of a default is something which does not support a claim for money damages?
Our position, Your Honor, is that the plain wording of 1250 North SD's own counterclaims brings it within the scope of Section 1112. My position isn't that there's not a circumstance in which a foreclosure that was occurred when there was no default isn't subject to that.
You say it brings it in. Well, I read 11.12, and I didn't see anything in there about a declaration of default. I don't see anything in there about commencing a foreclosure proceeding.
I absolutely agree. What it says is that the claim is based on allegations that the lender acted unreasonably, which the counterclaims themselves are replete with allegations the lender acted improperly, unreasonably when it did all of these things. Justice Reed looked at that and said there's no distinction between improper and unreasonable. It's the same word. And their own allegations are what makes
Basically,
it fit
why,
within the
if
scope.
that was the point and these are sophisticated parties, why didn't 11.12 just say you cannot sue us for money damages?
Because
That is basically what you're saying.
that's not our position. Our position isn't that you can't ever sue us for money damages.
So when could you be sued for money damages?
I think there's a whole host of circumstances in which we
Such
can
as?
be sued for money damages. Hypothetically, had lender actually breached the agreement and it was something that was not tied to reasonably or unreasonably.
Commencing a foreclosure proceeding when you're not entitled to, declaring a default when you're not entitled to, constitutes a breach of the contract?
Our view of the counterclaims aren't consistent with those allegations. That's not what the counterclaims say. Justice Reed reviewed the counterclaims in whole and determined that in substance, they're alleging that we didn't allow them to cure the default that occurred. There's no serious allegation in any of the counterclaims or these pleadings that the underlying transfer didn't occur. The guarantor's pleadings admit that interests were transferred. 1250 North SD's pleadings admit that these transfers occurred. In fact, 1250 North SD is engaged in separate litigation in California with the guarantors over these very transfers and the fact that they caused this default. And that reasoning is why the counterclaims are very carefully pled to say the portfolio party's position is there's no event of default. The portfolio parties told us that Ladder was aware of these transfers. They don't outright say in the counterclaims that there was no event of default. Their main beef with Ladder is that we wouldn't allow them to cure that default. They spend pages in the appellate briefing and in their counterclaims complaining about the actions they were trying to take to fix the transfer that Mr. Burns' clients made, not that it didn't occur. And if I could spend just a moment responding to Mr. Burns, on the guarantor's claims, we actually think the cases, the major decisions, none of that matters. Nothing in the definition of control in the applicable loan document says that it has to be absolute control. The guarantors admit that PHRI had day-to-day control over the entities. The definition of control that's in the loan agreement itself simply says control means a person or an entity that has directly or indirectly the power to control, or direct rather, the management, policies, and activities of an entity. It doesn't say that they have to be able to do that without talking to anyone else or without any other issues. I will concede, I mean, obviously the operating agreements of the higher level entities here contain a number of restrictions on that control. But no one disputes that PHRI had day-to-day control. They admit in their opening brief and in their reply brief those absolute facts. And I think given that, I actually do believe this is likely subject to a decision as a matter of law based on the definition of control and their admissions in their papers that they had day-to-day control.
Thank you.
Thank you.
I think it was pretty telling when the panel questioned my adversary about, well, in what circumstances can a lender be sued under this contract? And his only answer was, when there's a breach of contract. There's a breach of contract here. It's clear. What Ladder has attempted to do is point to an allegation in the counterclaim that calls the declaration of default as being improper, as though it is an accusation of Ladder actually breaching an obligation to act reasonably or promptly under Section 11.12. That's not what the counterclaim says. We don't allege that Ladder breached an obligation to act reasonably or promptly, which would trigger Section 11.12 when declaring a default. We're just using term of art language in our counterclaim when we say their declaration of default was improper or was unreasonable. one thing has absolutely nothing to do with the other. It's two different circumstances. Those are just terms of art, and then there's actual obligations in the contract. As far as the positions go about default or no default, we've always taken the position there's no default here. It's clear in the record. There's letters going on back and forth, letter writing campaigns and wars about our position has always been that there's no default. But what we did do is attempt to avoid litigation and try to figure out a way where we can work this out. We knew that they were ultimately concerned about the 80% owner. We knew that they were ultimately concerned about who was controlling this property, and we were the ones who are ultimately in control of the property. And so what we did try to do is attempt to figure out a way to satisfy the lender here under these circumstances. We told them, look, if you guys are concerned about an entity 4 layers removed from the borrower effectuating a transfer of its minority ownership, fine, we'll take over the project and we'll conduct the day-to-day management because that's what our operating agreement allows us to do, and that's the operating agreement you required us to sign with our minority investors, and they objected to that, and ultimately that's why we're here. But
Thank you.
respectfully request the reversal. Thank you, Your Honors.
Your Honors, a couple of short points. I'm happy that Mr. Gardner acknowledges that this matter is, the default issue is ripe for decision. It ought to be, because a party to these agreements ought to have been able to figure out by reading them whether it was subject to the restriction on transfers. So it makes sense that this is an issue of reading the agreements and understanding the law and applying the law to the loan agreement and the operating agreement. The question Mr. Gardner raises about, well, it's admitted that we were the managers of the property. Yes, day-to-day managers, that's admitted. And so it doesn't matter. If we had the ability to manage, to control any aspect of the operation, that's control. I would urge you in deciding what control means and whether the major decisions restriction on control vitiates control. I'd urge you to read, usually footnotes can be skipped, but I would urge you to read footnote number 2 on page 8 of their brief, in which they explain exactly what the control provisions are meant to do and the transfer provisions. They say, a lender wants to know who controls its collateral. If that's important, here, the major decisions clause says the majority owner controls the collateral. And so it's irrelevant that we were the day-to-day managers when we really couldn't do anything without their consent.
Thank you.
Thank you.
Thank you all. People v. Ephraim Santiago.
Good afternoon. Karen Brill for Ephraim Santiago. Mr. Santiago's right to a fair trial was violated when sweeping and literally countless uncharged bad acts were admitted that depicted him as a dangerous and violent police officer comfortable with taking the law into his own hands. A propensity inference that was directly implicated in the allegation that he trespassed into Ms. Ruiz's home in order to serve her with a custody petition.
Counsel, isn't it right that with regards to whatever propensity argument that you're making here, that affected the testimony of Ms. Ruiz? And the testimony that Ms. Ruiz provided resulted in an acquittal of all the charges here except for the sole charge where there were independent witnesses, disinterested witnesses. So how was the defendant prejudiced?
So a lot of the testimony was about Ms. Ruiz's testimony as to uncharged bad acts. One of the things she testified to was that Mr. Santiago was on probation with the NYPD. That's a more objective fact that could have easily prejudiced the jury beyond their willingness to discredit a lot of her testimony, at least beyond a reasonable doubt as to the other charged incidents.
It seems like the jury discredited all of her testimony, right? But for the neighbor, it's questionable whether the prosecution would have gotten a conviction for trespass.
I think what we know is that they discredited her beyond a reasonable doubt as to the charged incidents. That doesn't mean that they didn't use any of her testimony to make the trespass story more plausible, particularly where they were never instructed.
Well, for the trespass, we have, not only did we have her testimony, but we had her husband's testimony, who he said that he saw the defendant present. We had the daughter's testimony that said that she heard the defendant's voice. And then we had the disinterested witness, the neighbor, that saw the defendant leaving the premises.
So I do want to clarify, there were no disinterested witnesses. Those neighbors were people who identified as Ms. Ruiz's sister in a common, not in a blood sense, but in a close friend sense, and the other one was the godmother of one of her children. These were people who were very close to her. What we essentially had were two sides of a child custody dispute who were testifying to different stories about the trespass. And the jury was obviously very closely torn about that because they issued 3 separate jury notes about Ms. Sanchez's testimony that she went in alone while her brother, Mr. Santiago, waited in the driveway. So this was not such a clear-cut, multiple witnesses versus one witness thing. This was 2 sides of a custody dispute that had gotten ugly, and the jury was clearly concerned about the trespass conviction as well. And there's every reason to believe they could have used this uncharged bad acts evidence as propensity because they were never instructed not to use it for exactly that purpose.
So you're saying, I'm sorry. Go ahead. So you're saying that there's a possibility that the jury used the propensity argument, the prior bad acts, with regards to the trespass, but not to strangulation, criminal obstruction of breathing, assault in the second, assault in the third, menacing in the second, criminal mischief, and criminal possession of a weapon.
I'm saying it's very possible that the jury did not credit Ms. Ruiz beyond a reasonable doubt as to her testimony, but that they still gave some credence in determining which trespass story was more plausible. Again, this was a jury.
And that is based on what? It seems to me that it's based on pure speculation, and even more so, less so on what exactly the facts in the case were and the testimony that was presented in the case.
Well, this court has repeatedly said that a jury will naturally use propensity evidence in exactly that way, which is why there's a need to instruct them not to.
So there was no instruction by the court there was no limiting instruction given by the court?
The court 3 times said that the evidence was being admitted for her state of mind and that it could not necessarily be considered for its truth.
Right,
That's
and
not the
was there
correct.
not a charge at the end of the case also in terms of the use of the testimony?
There was not. There was at no point any instruction not to use this evidence as propensity evidence, and that's the.
Wait, I'm sorry. There was no Molyneux charge given at the during the court's charge to the jury?
No, Your Honor. There was no Molyneux instruction given at any point. There was what seems to have been a kind of hearsay type instruction.
I thought there was a limited instruction given by the court.
Again, the court instructed not to use it necessarily for its truth. It was the wrong instruction. There was never the correct Molyneux instruction, and that is why the error here was so prejudicial, because there was every reason to believe that the jury would do what it was told it was allowed to, or would not refrain from doing what it wasn't told it couldn't.
Did the defense counsel object to that charge when it was given?
No, Your Honor, he did not, but he did object at the Molyneux hearing to the problems with the Molyneux proffer. Sorry, the last thing I'll say, I see my red light is on, is that where the evidence should have never come in the first place, it's putting the objection does not need to be made to the absence of the limiting instruction because the evidence should have never come in at all. The lack of the limiting instruction really just deepens the prejudice here. And because of that, we ask this court to reverse. Thank you.
Good afternoon, Your Honors, and may it please the court. My name is Shane Magnetti. I represent the office of Darcel Clark. This defendant was acquitted of 18 counts relating to 5 different domestic violence incidents. The jury only convicted him of trespass because in total there were 5 witnesses placing him inside of Wendy Ruiz's home. This shows that even though the jury did not credit Wendy's testimony about the other 5 incidents, The fact that there were 4 other witnesses who either saw or heard him inside of Wendy's home that night was overwhelming proof that he did commit the trespass.
So the charges in which he was, the charges of which he was acquitted, those charges were based solely upon the testimony by the complainant.
That's correct, Judge.
And then
Solely-
this one charge, trespass in the second degree, I think?
Yes.
This was the, this was the sole charge where there was corroboration of her testimony.
That's correct. That was the only charge where they could corroborate it with other evidence. And on that charge, there were 4 other witnesses in addition to her that either saw or heard the defendant in her home that night.
So the limiting instruction was that that testimony was being admitted for the purpose of showing why she had not reported the assaults, the domestic violence.
More or less, Judge. The limiting instruction was that the jury was not to consider that evidence for the truth of the matter, but instead for the state of mind of Wendy Ruiz. Now, the court gave that instruction 3 times. Counsel never asked for a different instruction. He never objected to that instruction. And at the court's pre-summation charge, never asked the court to give any additional instruction about it. I would also like to point out that the Court of Appeals has upheld that hearsay instruction in the Molyneux context in a case called People v. Morris that you can find at page 40 of my brief. So moving on to the Molyneux point itself, I'd like to point out that none of the Molyneux evidence pertained to the trespass charge, and the jury acquitted defendant of every count that the Molyneux evidence did pertain to. Counsel says that the prosecutor was able to elicit countless bad acts. Counsel elicited 5 bad acts. It came up 5 times, each time in the context of Wendy explaining why she did not report the charged conduct that the defendant was ultimately acquitted of to the police. None of the Molyneux evidence ever came up in the context of the trespass, obviously because it was offered to explain her delay in reporting, and she reported the trespass.
But the Molyneux, I mean, the prior bad acts did, I mean, the argument, I guess, is reasonable that it did kind of pour on to the jury in terms of exactly what the defendant allegedly was like. Police officer, currently suspended, making threats, etc. So, I mean, the argument by your adversary is the jury was made aware of this, they knew this, and although they acquitted on those 8 other charges, this still played a role, that information, that evidence still played a role in their conviction on the trespass.
Well, here's why it did not. My adversary's argument is that the threats to either kill Wendy if she reported, or the threats to take Kanye, or that he had connections, evinced his propensity to abuse authority. None of those threats speak to his authority as a police officer. Like the threat to kill Wendy Ruiz, he doesn't have authority to do that. The threat to take Kanye, that's not really authority he has as a police officer.
And I thought there was also a statement made that because he was a police officer, no one would believe her.
That was proffered, yes, and she did mention that. But again, that really doesn't pertain to the trespass charge or what he was actually convicted of. He was convicted of trespass because he broke into Wendy's home at 1:45 in the morning. That's not an abuse of authority. It's not. It doesn't matter that he was there to serve a custody petition. It matters that he was there at all, and that's why it was not prejudicial in terms of the trespass charge. And for those reasons, we ask that you please affirm.
Thank you.
Thank you.
To just briefly pick up on what Judge Weber had just mentioned, that the Molyneux evidence wasn't admitted for the charge of incidents has no effect on how prejudicial it was to the jury about the trespass. The point is that the prosecutor was allowed to elicit that Mr. Santiago was on probation with the NYPD, which was an objective fact pretty easily separable from Mr. Ruiz's credibility, and that he, quote, always threatened to use his connections as an NYPD officer to take Kanye. That's the exact kind of brazen contempt for the law that could have easily convinced the jury to take Mr. Ruiz's side in the custody dispute over the trespass narrative over Ms. Sanchez's, that she went in alone while Mr. Santiago went in the driveway. And that's the exact reason why limiting instructions are so important, because once that information is heard, a jury is tempted to use it as propensity, which is why they need to be told they can't.
So even though the jury is told 3 times that they're not to use it for propensity,
Again, they were never told not to use it for
Well,
propensity.
and they were told the reason that they were supposed to use it.
Yes, but they were told that it was not necessarily being admitted for its truth, suggesting that they could have used it for its truth or really for whatever reason they wanted. And that's why it was so deeply prejudicial here and requires reversal.
Without an objection by counsel.
Yes, and viewed in summation with the objections he made at the Molyneux hearing about the breadth of the Molyneux evidence being admitted. If I could just briefly add my one last note on that point, is that part of the reason why the breadth of the Molyneux evidence is so problematic is the suggestion that he was always making these threats moves this from Molyneux evidence into character evidence. They're saying that this is the kind of person he was. He was always doing this. Molyneux is about specific bad acts, and that's what defense counsel objected to at the Molyneux hearing. And so we ask that this court reverse.
Thank you.
Thank you.
National Auditing versus 511 Property.
Good afternoon, Your Honors. My name is Robert Kaplan. I represent the defendant appellant, 511 Property, LLC. As you know from the briefing, our three principal arguments on this appeal are: one, respondent cannot enforce a party's agreement because it did not perform its obligations under the agreement, did not perform the audit required by that agreement. Two, respondent forfeited any right to any recovery under the agreement because it breached the fiduciary duty it owed to appellant. And three, respondent induced appellant to enter into their agreement with false and misleading statements.
So this is a non-jury trial,
Correct, Your Honor.
and the judge made determinations as to, obviously, the evidence as well as the credibility of the witnesses?
I don't know, Your Honor. You can look at that. It's the most in my 42 years of practice, the most cursory decision I've ever seen, particularly one after trial. So who knows what the trial court judge was actually deciding. In any event, this court is authorized to make a de novo assessment of what determination is supported by the weight of the evidence, and to the so the claim of that the first two arguments are based entirely upon undisputed evidence, and with regard to the fraud claim, all of the evidence points in the appellant's direction, because the witness, respondent's witness, she contradicted her testimony at trial, contradicted her deposition testimony, and also when the respondent's witness, in her own email, which is, you find at page 614 of the record, when she had her opportunity to summarize all of her communications with the appellant prior to the execution of the agreement, did she say anything about filing a refund application for the tax credits? Absolutely not. What she said was perfectly consistent with the appellant's.
Well, if she didn't say anything about it, why did you seek out a carve-out for tax work done by the Goldberg firm?
As explained by our witness, Your Honor, the concern was there anything, any work going on that could possibly overlap with what the plaintiff said it was going to do? Well, this tax certiorari work.
So why didn't you also seek a carve-out for 421A work done by the Seiden firm?
Because one, that work is already done, was already completed. Furthermore, most importantly, if they wanted to audit that, they should go ahead and do that. They could have audited whether or not.
What is your explanation for the email that Migliaccia sends to the Department of Finance about the 421A refund? If this was something which you knew about or should have, why does he send such an email to the Department of Finance?
Because if you look at the record, Your Honor, you have to remember that the respondent was sending us these bizarre emails claiming that this had nothing to do with the 421A exemptions. You can look at that. Remember, they've recanted those emails. So because they were making these bizarre arguments, so we decided, okay, let's send a perfectly neutral inquiry to the Department of Finance.
Sir, at trial, the court could easily have determined that defendant's attorney, who claims he was fully aware of the $1.5 million tax credit on Lot 33. I'm fully aware of it. I knew it was in my back pocket. And yet he wrote, as my colleague pointed out, he wrote an email. I don't understand. Why did we get this $1.5 million check? Point one. Point two, his client, Mr. Salim, had argued or testified that the whole cold car approach was to audit utility bills, not real estate tax credits. And yet your client's lawyer made changes to the proposed one-page agreement. He reduced the percentage of the commission, and he put in carve-outs specifically for tax certiorari work done by the Goldberg firm, which involves real estate taxes.
No, it involves real estate assessments.
Just give me a second.
Real estate assessments.
So when the court, Judge Lanton, hears this kind of testimony and weighs credibility, why is it so beyond the pale? Because we certainly can't weigh in on credibility to find Dr. Berger more credible than Mr. Magliaccio.
Because you have Dr. Berger's own emails here. She doesn't say a thing about tax credits. There is no, when in her deposition, she didn't say a thing about communications about tax credits. And in any event, a credibility determination would only bear on the fraud claim. The other two causes of action are based exclusively upon undisputed evidence. Did the respondent perform the audit required by the agreement? You know, this case has been going on for more than 6.5 years. This is its second trip to this court. In all that time, after all that litigation, can the respondent cite a single case, or commentator, or treatise, authority, or soothsayer, or anyone who could say that their work constitutes an audit?
Well, since they're not here, the answer would be no. Thank you very much.
Thank you, Your Honor.
Runway towing versus New York City Department of Consumer and Worker Protection.
May it please the court, my name is Jamison Davies for the appellant. This court should reverse Supreme Court's decision and dismiss Runway's petition. While Supreme Court correctly found that DCWP rationally concluded that runway towing repeatedly violated towing regulations, it mistakenly concluded that the decision not to renew Runway's license was a penalty and found it too harsh. But a non-renewal is not a penalty, as this court recognized in Testwell, and the regulations delegate to DCWP the discretion to decline a renewal license based on any prior violations of the tow regulations. Once Supreme Court concluded that DCWP's decision was rational, that should be the end of the case. Even if the court were inclined to accept Runway's invitation to overrule Testwell, ignore the Court of Appeals decision in Daxor, and treat non-renewal as a penalty, non-renewal hardly shocks the conscience here. Runway persistently overcharged customers, tacking fees on their bills to avoid a cap on regulated rates. It continued to do so even after DCWP informed Runway that the practice was illegal, and it didn't produce the records that would print a full accounting of its overcharges. And it remains unrepentant, contending in its brief that it was authorized to charge fees that the Supreme Court agreed violated the law, and a decision that Runway didn't cross-appeal.
Counsel, just to be clear, there's no cross-appeal here, correct?
Correct.
So all the findings by the Supreme Court that you just reiterated quickly have not been challenged?
Correct.
And even in the Article 78 petition, there was no attempt to say, oh, mea culpa, we made a mistake, we should not have overcharged.
No, there's no dispute that the charges, there's some argument, although I don't think it's preserved because there's not a cross appeal, that the regulations don't specifically preclude them from making these charges, but they never contested that they did in fact submit these charges that are not authorized by the rules. The rules set a hard cap on how much you can charge for various types of towing, and they added surcharges basically to get around the hard cap.
Something about cleanup fees or something like
Yeah,
that?
cleanup fees, pull-out fees, credit card surcharges, things like that, which, you know.
But this, again, this is a renewal application, right?
Correct. It doesn't even get to the point of whether or not there's no penalty here. That's the fundamental error by Supreme Court, as this court found in Tesswell, and even just this year in the towing context in casino towing, a case that the respondents don't cite or distinguish in any way, applied Tesswell to the towing industry and said a denial of a renewal is not the same as a revocation. You have discretion to deny renewal for any reason, any prior violation that the court rationally found, or that the agency, sorry, rationally found. Here, the agency rationally found hundreds of prior violations, and on that basis, there was a sufficient reason to deny renewal of the license.
Thank you.
Good afternoon, Your Honor. My name is Errol Margolin. I'm counsel for Runway Towing. The court, we're here to ask the court to affirm the lower court's decision. And in this particular case, the lower court properly held that the discipline imposed by the Department of Consumer Affairs and Worker Protection was shockingly disproportionate to the offense.
Well, that's the whole issue. Is it discipline, or, I mean, it's a denial of a renewal? How is that discipline?
The CPLR and the Pell decision specifically authorize a lower court to review the measure of punishment or discipline imposed by the agency which issued its ruling. In this particular case, Runway is the single largest tow operator in the city of New York.
But the issue of punishment applies in some Article 78 proceedings. For example, if a teacher is disciplined and appeals it to us. But this is not a discipline issue. This is a denial of an application.
Yes, but the court concluded that this was an abuse of discretion based upon the determinations that the Department of Consumer Affairs found. We did challenge those determinations. As a matter of fact,
Is the test whether it's an abuse of discretion or whether it's not rational?
No,
or arbitrary and
there were two
capricious?
determinations.
What's the standard?
May I please? There were two determinations made. The first were the determinations.
Would you like to answer the question, please?
Would you repeat
the question posed by Justice Friedman was, what is the standard? Given the fact, again, that we're talking about in Article 78 for the purposes of the denial of the renewal application.
The standard was an abuse of discretion. Did the agency abuse its discretion?
It's not whether or not the determination was arbitrary and capricious?
It was an abuse of discretion, Your Honor. There were two parts to our challenge. The first was that the determinations themselves were not proper. I didn't file a cross appeal on those simply because I thought we would go back to the agency and the agency would fashion an appropriate remedy.
Let's grant you that it's an abuse of discretion standard. Is there an abuse of discretion for an agency to say, well, you didn't respond fully to our subpoenas, you didn't respond at the time you were supposed to, you violated certain provisions of the administrative code, for them to come back and say a license is up for renewal, we don't think we're going to renew? Is that an abuse of discretion?
Yes, based upon the facts of this case. Each of these cases is factually dependent upon what the licensee did or didn't do. In this particular case, charging a $4.99 credit surcharge is hardly the basis.
How many times was that done?
Well, there were three classes of violations. The first is the credit card surcharge, which was
cleanup fee?
237 times total. That's one class, perhaps 75. 75 violations, they're the same violation, were for something called highway services. So a highway service charge is if a car is disabled and it has a flat tire, the administrative code authorizes the tower to charge $25. The police department, who Runway works for, demands that Runway tow the car off the highway to fix the tire. That's $125. So Runway would charge $150. And every time there was a $150 charge, the department said the $25 surcharge is the only charge you're entitled to charge, and it's a violation. And they did that 75 times. They reviewed 50,000 tows. And out of the 50,000 tows, they found 237 violations.
But if those 237 violations were willful, and it cost consumers some money that your client was not allowed to charge, why isn't that enough reason for the agency to decide not to renew your license?
I think that the court concluded that 237 violations out of 50,000 tows is not a substantial number, and it's really not a violation. In order to have a violation under the administrative code, you're supposed to have an oath hearing. You're supposed to be charged. You're supposed to defend the charges. There was never an oath hearing on these things. What happened is—
Not charges because we're dealing with the license renewal. We're not dealing with the license revocation.
Yes, I know. I pointed that out in my appeal. And what happened is that during the time that Runway had a license, it applied for renewal. The DCWP simply let the clock run out and made its determination 8 months later. And they said, now it's really a renewal, and it's not, we don't have to go through the revocation or suspension part. We're just going to deny it based on our own determination.
Thank you. Thank you very much.
And please, Court, I'll be brief and just make 2 quick points. First, I think the correct standard is whether DCWP had a rational basis for denying the license non-renewal, or whether its conclusion on that front was arbitrary and capricious, which it clearly was not. There was evidence of substantial violations, which were just from a representative sample. It didn't analyze every single tow, and also it couldn't analyze every single tow because it didn't have the records that Runway was required to maintain, which is a separate violation.
So the 237 isn't out of the 50,000, it's out of a smaller number.
Yeah, I believe they took—
And you don't know that it's just 237.
Correct, Your Honor, because
you know that there were 237, but you have no reason to believe, you cannot be sure that there weren't more.
Correct, correct. And even those are sufficient basis, I think, even standing alone, even if that were correct, that they were limited to that. That's still hundreds of violations, attaching fees to vulnerable people who have been just in a car accident and essentially, increasing by as much as 50% the regulated rate.
Well, they claim that the police department charges or imposes $125, so it's $25.
There are certain circumstances under which they're allowed to add an extra $25 fee, but the DCWP concluded that in the cases where it found a violation that did not fall within that $25 additional charge authorization, and there's only a subset of the violations that were
It
found.
could very well be, if the number was just 237 out of 50,000 tows, what you've done is not very reasonable. But that's not the test. I mean, it's under an Article 78, it's more one of arbitrariness. And when you apply that test, it brings you to a different place than when you apply a reasonableness test.
That's correct, Your Honor. And also DWCP is allowed to be forward-looking here, and Runway, even in their briefing, has said that these fees are not illegal. They haven't given any indication that they're going to continue to charge them, which we'll just end up back in the same place again with hundreds of more people who have been charged illegal surcharges.
Thank you.
Thank you.
People versus Derwin Mercer.
May it please the court, my name is Elizabeth Vassley, and I represent appellant Mr. Derwin Mercer. The prosecution failed to establish probable cause at the suppression hearing for 2 reasons. 1, the description was overly general, and 2, there was a missing link in the chain of the fellow officer rule. First, I'll address the description. The court ruled that, quote, the
Counsel,
detailed...
how do you distinguish what happened here from Ketchum?
In Ketchum,
Because I read Ketchum several times, and it seems to be on all fours.
in Ketchum, Your Honor, there was actual participation in the drug sale. Here, on the other hand, the ghost did not personally participate in the drug transaction. He was a point person that was, and we don't know how, but he was receiving information from the undercover.
But that's the way that this undercover buy and bust was designed, right?
We don't know according to the record, Your Honor. The only officer that testified at the hearing was Perez, and Perez testified that he didn't know, he said he had no clue how the ghost and the undercover communicated. He didn't know if she communicated to a supervisor who communicated back to the ghost. There was no evidence of text. There just wasn't any information to definitively make this link, and that was the people's burden to prove that. And that sentence right there shows that the chain is broken. I will go to the description point unless there's any further questions about the fellow officer rule. The court ruled that a detailed description in the ghost transmission gave the officer probable cause to arrest Mr. Mercer, yet this description was far from detailed, and that was error. It did not contain the suspect's height, no age, no weight, no facial characteristics, no accessories, no
But isn't it
unique...
true, counsel, that this description, however light as you describe it, there were a lot of people in that area, and the defendant was the only one that met that description?
That's right, Your Honor, but this was a heavy, densely populated street with lots of foot traffic. So although in a freeze frame, Mr. Mercer may have been the only person, that would change in mere seconds because people are walking in and out of this busy area. So you can't say that at that single moment that offers much probative value. If this was an isolated location, then that would hold significantly more weight. But because there's just so many people moving through this area during rush hour, that cannot bootstrap an otherwise weak description. And I'll go back to the fellow officer rule. The prosecution was required to prove Aguilar Spinelli's two prongs for every officer in the chain. And that includes reliability is presumed for officers, but basis of knowledge is not presumed for officers. So they just had to put forth every single officer in that chain and the basis of knowledge, and there is that gap in that link that's between the primary undercover and then how the arrest and the ghost, and we don't know how they communicated with each other. If there are no further questions.
Yes, you have time on rebuttal. Thank you.
Good afternoon, and may it please the court. David Gagne for the people. Defendant's arrest was amply supported by probable cause. The description transmitted by the ghost gave information about the suspects.
Counsel, there's definitely a gap here, right? We just don't know where the ghost got his information from, right?
Your Honor, there was a fair inference to be made by the suppression court that the information that the ghost transmitted to the arresting officer came from the undercover officer. This is a buy and bust operation. So this transmission did not, come out of the blue. This was an intended and anticipated outcome.
Well, I just asked the adversary, how does this case differ from Ketchum, right? In terms of the description of the undercover buy and bust and the roles of the officers involved, how was that description in this case? How did it equate to the description in Ketchum?
If I'm understanding the question correctly, are we discussing the
operation of the buy and bust, right? The roles of the ghost, the roles of the hand-to-hand person, the roles of the other officers involved. Because in Ketchum, there was a clear description as to that, and the court was able to rely on that description. How was that description in this case?
So the roles that were described in this case, the undercover officer was given the role to buy the narcotics and to make the signal to the other officers that a buy had occurred. And the ghost role was to...
Was there any testimony what the signal was that the ghost received from the undercover that did the hand-to-hand?
No, Your Honor, there was no testimony about what the signal was.
He just said a positive sign, but it doesn't, he testified a positive sign, but he didn't say what that meant.
That's correct, Your Honor. And because this buy and bust did occur inside a building, as I stated in my brief, what most is likely is that the positive sign didn't come until after the arresting officer, the undercover officer had left the building and had communicated with the ghost via cell phone. There was really no other way that the ghost officer would have been able to have provided the detailed description of the suspect. Just moving briefly to the fellow officer rule. The suppression court did correctly apply that. The police officer was justified in relying upon the ghost transmission. Under Ketchum, that was clearly a reasonable inference to make. And unless there are any further questions, I just ask that you affirm. Thank you.
Thank you.
My adversary's answers to your questions by saying what most likely happened and what's in the respondent's brief that says the most likely scenario is that the undercover texted the ghost, those equivocal likely shows that there just was a gap here, and that this leap can't be taken.
Well, the gap is basically that we do not know who actually transmitted the description, right? That's the gap. Who actually transmitted the description to the ghost?
That's correct, Your Honor. Whether it was the undercover herself, whether it was to a supervisor, whether it was to a supervisor to another officer, we actually, based on the testimony, don't know.
But under the fellow officer rule, is that not enough that we know that one of the participants in that buy and bust operation transmitted the description?
It's not, Your Honor, because Paris makes clear that that the fellow officer is allowed as long as the prosecution establishes the basis of knowledge for each officer in that chain. So while it could have been just a simple line of testimony that she texted him, it could have been hearsay, but because they didn't establish that link of basis of knowledge, the fellow officer rule doesn't work.
But we do know that it was one of the participants in the buy and bust operation, so it was either the undercover or the ghost.
We actually don't know for sure, Your Honor, because he didn't know, and there was no testimony from Officer Perez that it had to have been.
Who else could it have been?
It could have been another police officer we don't know of. There were even 2 civilian females involved in the operation. We just don't know because there was no testimony that conclusively established that basis of knowledge for that section of the chain.
Thank you.
Thank you.
Regan versus W Associates.
May it please the court, Ephraim Wertenthal for the appellant. In this case, the motion court improperly restricted the definition of foreseeability to the intent of the building owner. The definition of foreseeability is far more broad than that, and it should be guided by the Court of Appeals decisions in Towers and Leskovich.
So are you seriously arguing that it was foreseeable that a 50-year-old woman would climb up a ladder, jump from 10 feet above the roof surface, jump down onto another surface, and then walk backwards in the dark without looking where she was going, and that was actually foreseeable?
And let me just say, walk backwards on rocks on that area in the dark.
The case law is clear. The actual manner in which the accident would happen, in terms of the whether or not it's foreseeable, they don't have to understand that a person would be going up to take pictures, walk backwards. But The risk involved in not having a fence is that somebody would inadvertently walk off. Would a person walk up the ladder and go to the upper roof? Yes, that had been done many, many, many times before by tenants in the building.
Many, many times. There was testimony by one young person that she had seen people up there some number of times, but not many, many times.
Yeah, she had been up there herself. Maria Scovell, the plaintiff's daughter, had been there
She
10 times, as many
She said that
times.
she'd been up there, she didn't say 30, it was more like, she said under 10.
Up to 10
And that
times.
she'd seen a few other people up there, but that's not many, many.
Well, it's many times. She said people would routinely go there with lounge chairs and smoke because they were not allowed to smoke on the roof. She said that she would quite often, very often.
Routinely.
She didn't say one time. She said this was something that tenants would do. It's clear from her testimony. It's not something that you saw on one isolated incident that somebody took up a lounge chair to go up there. She was saying tenants would go up there with lounge chairs to smoke and to drink. And they did it because they were not allowed to smoke on the regular roof deck. So, I mean, the court is asking, well, was it foreseeable that somebody would take pictures and walk backwards? It is foreseeable that somebody would be up there because...
Sometimes people would bring lawn chairs to the bulkhead roof, and she recalled seeing people smoking and drinking and having a little party up there on one occasion.
She didn't...
I'm sorry, I thought I read that correctly, record 709. I know it's a little dark in here today, but it says, on one occasion.
Okay,
She recalled seeing people smoking and drinking and having a little party up there on one occasion.
I'm reading it.
Record 709.
I'm reading it right now. It was kind of secluded in a way, she says. I know some other people go up there. I have this one memory of people being up there, smoking and drinking and having a little party up there.
Okay.
I mean...
I thought that's pretty much one occasion. But so, counsel, you had just said a little while ago that there should be a fence. At what point should the fence have been? Where the ladder was, where she jumped, the surface where, the area where she jumped from, the area where she landed, where the potted tree was? Where exactly should this ladder have been?
No,
Where
there was...
excuse me, this fence have been?
So there was a parapet which was 4.5 inches that surrounded the entire upper roof. Surrounding at the edge of the entire upper roof, there should have been a fence, a 42-inch fence. In the area where there was a 4.5-inch parapet, precisely in that area, there should have been a 42-inch fence.
And do we look at the building codes at all? The fact that the building codes, this was not a violation of the codes, right?
Well, our expert said there was a violation of the building code, section 327-344 of the New York City Building Code. It's also a violation of the multiple dwelling law, 62 sub 1, which requires all roofs to have 42-inch fences, no matter at what height. So it's clearly a violation of both the New York City Building Code, because it's a building that's in excess of 22 feet high, and certainly it's a violation of the multiple dwelling law because it doesn't even restrict it to 22 feet.
Well, you talk about the roof, though, but I thought the code talked about, excuse me, the code talks about the roof. Here we're talking about the bulkhead, right?
The bulkhead is also, it is a roof of a bulkhead. It's a structure that has a roof. The multiple dwelling law in the New York City Building Code does not restrict roof. The roof is defined, in fact, by the New York City Building Code as the uppermost slab. The uppermost slab in this building is the roof on top of the bulkhead. According to the very definition, that's 232 of the Building Code, 27-232 of the Building Code, a roof is defined as the uppermost or the topmost slab. The roof of the bulkhead fits very neatly into the definition of the Building Code. And
so the bulkhead would not be considered a structure above the roof?
It is a structure above the roof. It's a structure with a roof.
So therefore would not, so if it's a structure above the roof, does it still fall within the building code?
Of course it does, because it's part of the building. It is a structure. It's defined as a structure above the roof, but it has its own roof. The defense expert himself agreed that if it would be 22 feet high, at least in his initial affidavit, he said, it wasn't 22 feet high. If it would be 22 feet high, then it would require a fence. He never said that until his reply, and their reply, that's the first time he raises a new issue. Well, it's not even considered a roof because it's called a bulkhead. There's nothing that, there's no definition within the building code that says that the roof of a bulkhead is not considered a roof that's guided by the, or that's guided by the rules and the regulations of the building code.
Okay, thank you.
May it please the court, my name is Stephanie McDougall. I'm with the law firm of Dorff and Nelson, and I appear for defendant respondent. The lower court's decision should be affirmed for two reasons. First, the plaintiff's accident was not foreseeable. Second, there was no statutory code or standard of care which required a parapet or a fence on the bulkhead structure.
So if your expert conceded that if the roof of the bulkhead had been 22 feet above the roof of the building itself, that it would have had to, that the code would have required that there be fencing around the edge of it, why isn't that a concession that it is in fact a roof?
I don't believe that's exactly what my expert said. The code makes it clear that a bulkhead structure is not part of a roof. It's either on or above the roof. The language and the definition within the code is pretty clear that it's not part of the roof, and therefore it wouldn't be subject to that requirement.
And in terms of foreseeability, why not construct a fence around that area?
I think that the physical characteristics of the bulkhead structure render it prohibitive of recreational use. There was a plant in front of the ladder.
Well, certainly it wasn't prohibitive because people used it.
There's a pretty...
Now, you didn't put in any evidence to show that that it was never used or that the young person's statement was false.
The building superintendent testified that handyman go up to the rooftop deck several times a day, and he goes up once a day to the elevator machine room to check the machinery. He had never observed a tenant on the bulkhead or elevator machine room roofs.
But he didn't testify. There was no testimony about whether the others had ever observed anybody up there.
Can you repeat that, please?
There was no testimony about whether any of the other workers had ever seen anyone up there.
No, but unlike Powers and Lisakovich, there was no physical evidence to corroborate the plaintiff's daughter's testimony regarding prior use. There was nothing to indicate that the building was on notice of any use by the tenants. The building superintendent testified that he had never seen any cigarette butts or beer bottles or anything like that to indicate that tenants had been using the roof of the bulkhead structure for recreational purposes.
Also, isn't it just foreseeable that you have this structure with a flat top ladder, that people are just going to go up on it?
I would say no. They have an entire rooftop decked area equipped with lounge chairs to use.
And then you have a higher point, right?
That's covered with stones.
Which is always intriguing to people, especially those that want to take photographs.
That's covered with rock-covered stones. There's a 2-foot drop.
That's the lower bulkhead, right?
They were both covered with
Oh, they're
stones.
both covered, okay.
And there's a 2-foot drop in between the two structures. So I would say no, it's not foreseeable that a reasonably prudent person would climb up there, especially in the dark, and then to walk backwards taking photographs.
Well, you added something to my fact pattern. You said reasonably prudent. I just said a person.
If there are no further questions, I'll rest on the arguments within my brief.
Thank you.
Thank you.
Just going back to the amount of times people would be using that roof, this is page 717 of the record. This is Maria Scoville's testimony. Like, people go up there all the time. That's her testimony. People go up there all the time. I don't know how it could be any more, expressed than what she said. It wasn't just me and my friends. Like I was telling you before, people go up and smoke because you can't smoke in the regular area. I told you, people bring lawn chairs up there. It seemed like nobody felt you shouldn't go up there. I mean, there was a ladder leading up and everything. I mean, she says it outright, page 717 of the record. It's clear that this was a place that was used by the tenants routinely. She herself used it 10 times. She saw people go there. It was an attractive, secluded area to get away from everybody else. What the court quoted before, where she has one memory, that was referring to a party.
But what
She
about
once saw a party there.
what about the testimony that there were never any cigarette butts or other paraphernalia or garbage or anything like that found in that area?
I mean, so there was no cigarette butts. It's not an indication that nobody was there. People cleaned up after themselves. That's a possibility.
This is like the insurance case, like the insurance company would actually, do the right thing. And you're saying that folks in New York who are going to climb up to the surface and smoke and do whatever, they're going to take their cigarette, they're going to pick up their cigarette butts and take them with them.
Okay, listen, it's a high-end building.
It's a hypothetical.
It's a high-end building on Wall Street.
A
So.
high-end building, yeah.
Yes.
You talk about this ladder also. It's not like this is, it's one of these ladders you have to actually rung. These are rungs, right? That you're climbing up.
But Your Honor, in Powers and Leskovich, the person climbed out a small bedroom window to get onto the roof. And the Court of Appeals held that that's foreseeable that people will climb out of an apartment window to get onto a roof, which is not intended for getting onto the roof. This ladder is, the purpose of the ladder is to get onto
Is
the
there
roof.
any argument to be made that this is open and obvious in terms of being a dangerous foray?
No, because if it's dangerous, then that goes to comparative negligence. If something is inherently dangerous, the case law is clear, then the open and obvious is not a defense. It only goes to comparative negligence. It's dangerous. A person can inadvertently follow. She misjudged herself. She misjudged the step. People misjudge steps all the time. She didn't purposely lean over it or walk over it. She's an intelligent person. She took a couple steps back.
Okay, thank you.
And I just wanted, if I can just say 1 second, aside from the regulations and the statutory, there's also the common law negligence that we're alleging. Thank you.
Thank you. People v. Curtis McDaniel. So I always thank the last case of the day. Thank you both for waiting.
But not least, hopefully.
No, never least. We saved the best for last. It's a lot of pressure.
The fairness of Curtis McDaniel's trial was compromised beyond repair when, despite this case involving weapons possession allegations, the trial court permitted the prosecution to elicit deeply prejudicial evidence that he was wanted on a complaint of assault for a stabbing again and again throughout his trial. This evidence is particularly problematic because it creates precisely the type of propensity inference that Molyneux is intended to guard against. The outcome of this short trial hinged entirely on the jury's read of whether this plastic item found affixed to a keychain was just an ornament or a weapon. This prejudicial evidence brought this inanimate object to life. Components of the molded plastic ornament were all of a sudden conceivably waged in a stabbing.
Go ahead, I'm waiting.
Sorry. That's particularly harmful here, given how far from overwhelming the evidence against Mr. McDaniel was. The arresting officers who apprehended him testified that...
So, counsel, are you saying that because there was, it was injected that he was wanted on the I-card for a stabbing, that swayed the jury to conclude that this object that was on his keychain was a plastic knuckle as opposed to some ornament hanging on his keychain?
Absolutely. I mean, this object was a small molded plastic item, again, affixed to a keychain, and repeatedly, almost 10 times, there were references made to an I-card, a complaint for assault, a stabbing specifically. And that's precisely what it did. It brought it to life. It made it conceivable that, first of all, Mr. McDaniel had a propensity towards violence, and second of all, that he might have actually used that weapon, that item. And that's precisely the basis for our application.
But that was the whole point of the court allowing the testimony and also I think there was video surveillance, right, of them approaching him because the police officers were so aggressive in approaching him in their interactions with him. And so the court allowed that so that the jury would know why he was approached in the first place, right? Isn't that correct?
It was
That's the basis for the stop.
It was a forcible arrest.
Yes.
But the arrest was not a central issue at trial. Again, the trial really
Well,
hinged
yeah, because how else would the jury know the basis for the stop? They wouldn't know why the police in any way stopped him and ultimately found the plastic knuckles.
Defense counsel offered a much less prejudicial alternative, which is that the jury be instructed that the arrest was lawful and not to speculate as to police's conduct. That proposition wasn't really engaged with, and instead the trial court erred in...
It's not necessarily an alternative which is attractive to the people, but didn't the defendant himself want the jury to know about this?
And that was considered as a basis for the trial court's decision, improperly so. That is not one of the factors.
By agreeing with the defendant who wanted this information put before the court? Before the jury?
It's well established that that's not a decision that rests with a defendant. It's a decision that rests with defense counsel, and defense counsel was unequivocal about saying this would be deeply prejudicial to Mr. McDaniel. And Justice Scherzer even agreed. She said to Mr. McDaniel that I believe...
But the court was also very unequivocal about the fact that it shouldn't consider that the defendant was in any way involved with the stabbing.
The court... Might I respond? The court did say that, but in fact, the court said that he simply wasn't charged with that. That doesn't prevent the jury from creating the very type of propensity inference.
You should not assume from the evidence whatsoever he is guilty of any type of stabbing.
That's correct. The evidence still came out, and it was prejudicial to Mr. McDaniel, and it wasn't necessary to complete the narrative. I will reserve the rest of my comments for rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the court. Julia Gorski for the people.
Counsel, why wouldn't it have been sufficient to just instruct this jury that the arrest was lawful and then not to speculate about anything else? Or in the alternative, just say that he was arrested pursuant to an I-card without mentioning that it involved a stabbing?
That instruction, as the court properly determined, was not going to be sufficient here because the jury viewed the video of the initial stop, the pursuit, and the arrest. The object was never even seen until the defendant was arrested and being frisked.
And the police acted rather aggressively in that, didn't they?
I'm sorry, can you repeat that?
The police acted rather aggressively in that encounter.
Yes, Your Honor. The body camera footage showed the police officer jumping out of the car before he even came to a complete stop. He ran across an intersection.
Chased him like a block or so, right?
Yeah, before even that, he had grabbed the defendant, pushed him against a car, then the defendant fled. He slipped. Once he was on the ground, he was tackled, pinned, and arrested by multiple officers at that point.
And it's not sufficient to tell the jury that they acted in this manner because he's a wanted individual without saying that he was wanted for a stabbing?
I think the categorizing it
What
as
does the stabbing add to it?
It adds that the police officers acted in this aggressive manner and arrested him quickly because they thought he had, maybe that object on him and he was still a threat to the community. Just saying, oh, just assume that, this was lawful, kind of would make the jury speculate this was weird.
If the jury's charged, the presumption is that they will follow the judge's instruction.
That's correct, Your Honor. And any prejudice to the defendant was significantly minimized, not only by the court's two limiting instructions, but from the prosecutor's opening remarks to the summation. She clearly explained that the only reason why you heard this was to explain the narrative and why the defendant was stopped. And even in the police officer's testimony, the immediate next question of, why did you arrest him? Because he was wanted on a complaint of stabbing. Was he ever charged with that? No. It was throughout the jury had heard, he was never charged with this and you can't consider it. And again, the jury is presumed to follow the court's instructions.
I recognize that he received consecutive time, 2 to 4 on the CPW 3, and then 2.5 to 5 on the perjury. So we're talking about, was that 4.5 to 9? I did that quickly. Yeah, 4.5 to 9. That's a considerable sentence.
It is considerable, but running the sentences consecutively was totally authorized under these circumstances. The perjury was blatant. He was brazenly lying, saying that the officers had clearly planted this object on him, that they were lying because they had lied about
And this was in the grand jury.
That's correct. And that was after the grand jury had viewed the video of the officers after they arrested him, pulling it directly out of his pocket. And on top of that, the weapons possession charge in and of itself, he did receive the minimum sentence on that. He was a second felony offender, but it also fit within a pattern of assault and weapons possessions convictions that he had in the past. So given these two very separate offenses, the fact that the perjury was pretty extreme, the court was totally authorized to run it consecutively, and the mitigating factors that the defendant cites to, such as his GED, taking college courses and attendance and drug treatment, presumably, you know, the sentencing court took that into consideration because the people were recommending the maximum aggregate of 4.5 to 9 years, and instead he did receive the 3.5
He had
to
a
7.
robbed one in the past in which he received YO?
That's correct. And then while he was on probation for that offense, he also committed a first-degree robbery. And then he has multiple third-degree assault convictions, and in 2013, he had a box cutter on him during a fight.
I'm sorry, counsel, did you just say that the people's recommendation was 4.5 to 9 on each count?
In aggregate, so running them consecutively, it was the maximum aggregate sentence that he could receive. And if there are no further questions, we rest on our brief and ask that you affirm.
Thank you.
Thank you.
Your Honors, I'd like to first address your line of questioning for a respondent as to the video of the arrest being shown and the centrality of the arrest at trial. Like I said, that really wasn't the central issue. The video of his arrest was shown, but I'd like to talk about the trial court's reliance on People v. Morris and in rendering their decision and respondents' reliance on People v. Morris again, to stand for this idea that this type of propensity evidence can come in to explain police conduct. And I really would guard against applying People v. Morris to a case like Mr. McDaniel's. In People v. Morris, Mr. Morris was facing a resisting arrest charge and was taking issue with the circumstances of his arrest. None of those facts are present here for Mr. McDaniel. The video was shown of his forcible arrest, but short of being forcibly arrested and being Black, he has nothing else in common with Mr. Morris. And an overbroad application of Morris to a case like Mr. McDaniel's would lead to an adoption.
So what was the propensity evidence?
In Morris?
In this case?
In this case?
Yes.
That he was wanted on a complaint of assault.
How is that propensity evidence?
It creates the inference that he's somebody prone to violence, and again, where the central
Even though the court specifically states that is for the purpose of the jury, to some extent, completing the narrative or being knowledgeable as to why the defendant was stopped.
The very reason why a Molyneux hearing was held is because it creates this risk that it be used for a propensity purpose. And in fact, here it wasn't needed to complete the narrative to explain the circumstances of Mr. McDaniel's arrest. Morris is not applicable to a case like
in many ways, I thought that the video actually assisted the defendant because it created some sympathy for him because of the conduct, the aggressiveness of the police officers.
The video was not the propensity evidence. The 10 references to the fact that he was wanted for a stabbing that he wasn't being charged with in this trial was the thing that created the propensity. And that's what we're asking this court to reverse on.
Thank you. Thank you both.
I'm gonna see something. I think it's this light.